County Planning Commission meeting held this May 19th, 2026, starting at 5:30 p.m. We'll call this meeting to order, and we'll start with a Pledge of Allegiance led by Seth Cox, Commissioner.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. First item on our agenda to act on is approval of the minutes. And I believe the commissioners have all received the packet of the minutes from the prior meeting. Are there any corrections or edits that need to be made? If there's none, I'll entertain a motion.
Motion to approve.
Second.
Been moved and seconded to approve the minutes from the April 21st, 2026 meeting. All in favor say aye. Aye. Any opposed? None. Okay, the minutes have been approved. Moving to our next item. This will be a public hearing item, although I think we can start with staff report before we open the public hearing, right?
Yes.
Okay. So we'll move to this first item, the Rocky Mountain Power proposed land use ordinance text amendment, and we'll hear a report from staff. Thanks.
So, Mr. Chair, just to kind of point out to the commissioners, this is a land use ordinance text amendment. It's a legislative action, a little different than the conditional uses that you've had before you, which were administrative. But this will be a recommendation to the county commission. And that, so whatever you decide or recommend will be forwarded to the county commission for final action. Greg Robinson of our staff will give a little report.
Commissioners, this item is before you. The applicant, Rocky Mountain Power, has requested a text change in our land use ordinance to amend the requirements for a 300 kilovolt transmission line to remove the requirement for those transmission lines within a new corridor to a permitted use, meaning that they will, the anticipation is that a 300 kV line that is within a new corridor would now be amended to not be required to go through a conditional use process. This recommendation is supported by staff. We do anticipate that most of our conditional uses will transition to permitted uses with specific conditions applied that we have found through previous applications have typically specified specific conditions to be applied, and those conditions are now included in standards for those specific uses. This is not a practice that is, this is a practice that's kind of been encouraged by state code that we are continuing to go through that process, and you'll see more of these conditional uses transition to permitted uses with specific conditions in the future. So this is one of the reasons why it is supported by staff to transition conditional uses to permitted uses. Just to give you a little background, this application from Rocky Mountain Power was scheduled to be on the April Planning Commission meeting. Staff included recommendations that the applicant wanted to had received those later in the process and wanted to review those and work with staff to address the staff recommendations. They have done so, and they have amended their application to include some of the recommendations that staff has wanted to include, specifically to ensure compliance with noise ordinances that we currently have, Also, just to give you a little background, this as a conditional use, there were certain noticing requirements that were required. Staff has asked that those be included, and the applicant has included those noticing requirements. Those notices will go out, as you can see in the changes, 90 days prior to seeking acquisition of the right-of-way, and they will go to any landowner within 300 feet of the transmission line. The applicant is here to discuss those changes with you, and I will you'll probably have many questions, and I'll probably be best to have them address their application, and then we can address those comments if you have any.
Do we have the applicant here, the representative?
Commissioners, thank you for your time this evening.
And please
I
state
will.
your name too.
Yeah, my name is Cameron Sabin. I am counsel for Rocky Mountain Power, and have participated with staff in working through some of the language and technical issues associated with the proposed amendment. We also have some representatives from Rocky Mountain Power here, to the extent we have questions that go beyond my expertise on the statutory and ordinance side. We'll bring up the right person if need be. Just want to thank you for your time this evening. This is an important issue for us and for any utility, frankly, as we'll discuss. I want to also thank staff. They've spent significant time explaining to us and providing us with comments and concerns that they were hoping we could address. We have taken the time to meet with them, go through those concerns, and what we will present tonight is a reflection of that joint effort to try and figure out how to make this workable, and also provide reassurance that anything of this nature would comply fully with Utah County ordinances, which I'll talk about in a second. So we're here to talk about the amendment, but I want to just spend a minute talking about the process these kinds of transmission lines and large utility projects go through, because I believe there's a fair amount of misunderstanding about how this process works. And hopefully this is helpful. If it's not, then, or if you already know this, then I'm sorry for being repetitious. Lines of this kind, when we're talking about a 345 kV line and larger, they almost always have federal permitting, state permitting, and all sorts of other agency permitting that happens outside of this jurisdiction, and that in most cases is preempted by local ordinances. And so one of the issues that I know there's concerns about environmental assessments, environmental impact statements of that kind. Those are already handled at the federal level, and the company, for our part, and the utilities generally have to go through that process with the appropriate agencies at the federal level. So in other words, that happens every time you want to do something like this. That also includes Endangered Species Act, historical preservation issues, migratory bird issues, clean water and clean air issues. Those are all assessed by a different body within the federal government, and we have to go through that. It's a very complicated and time-consuming process, but that happens. We also, where it is relevant, there's tribal coordination that takes place with Indian tribes if reservation land is implicated. The U.S. Army Corps of Engineers sometimes has to weigh in, particularly depending on where a line like this would run. And then the Federal Energy Regulatory Commission, which monitors interstate transmission lines, also has input on these kinds of proposed lines. And then, of course, there are NESC or National Electric Safety Code requirements that any utility building these kinds of facilities has to comply with and ensure compliance with. And so why is this important? It's important to know that there are a whole host of concerns that I have heard and seen raised in this process that just are not things that we deal with here. There are things that are dealt with by other agencies that are very comprehensive. And so hopefully that helps address that point. At the state level, there's also permitting that happens. So we're subject to, any utility in the state of Utah is subject to jurisdiction and regulation by the Utah Public Service Commission. They have a section, or Title 54 of the Utah Code vests them with significant authority. They have also a set of rules and a bunch of other legal precedent that is, that imposes obligations on a utility for compliance. And so often we have to go and get approval before we construct a line. Sometimes we have to go after the fact and demonstrate that the line is compliant. But at the state of Utah level, they're definitely a primary regulatory agency that regulates us. Then you have the DOT, the Trust Lands Administration, the Utah Department of Environmental Quality. Again, on environmental issues, they are statewide. They regulate those issues and ensure compliance with state law. Obviously, we also have the Utah State Historic Preservation Office and Division of Wildlife Resources. All of those agencies have a role in these kinds of projects. And so when we look at the standards we're proposing tonight, one thing you can be sure of is the reason some of the standards we're talking about are described, for example, where the standard is that lines would be fully compliant with state, federal, and local law, is we're incorporating all of these processes into this to make sure that you can be certain that these things are already addressed at a different level. They're not excluded. We haven't excluded them from the permitting process. They're just handled by somebody else. So we also have local permitting and coordination that goes on, and that sometimes that's at a city level, sometimes it's at a county level. Those usually deal with more of from the construction standpoint or real property standpoint, or some water issues come into play there. And you will be familiar that in your own ordinance there are various requirements, and noise ordinances. The noise ordinance was referenced earlier. There's any number of things that happen at the local level, some of which happen before you or are subject to your jurisdiction, and some are not. And tonight we're going to talk about the ordinances that are specific to Utah County and what you can do, or what we're proposing you to do. And here is one of the primary concerns that was raised with Rocky Mountain Power. Was there is a noise ordinance in the Utah County ordinance presently. And what we're showing here is that when these transmission lines are constructed, the lines do have an audible noise. It's inevitable. You can't avoid that to some extent. You can reduce it. You can also ensure that the lines are located far enough away that you meet the standard of the noise standard within the corridor that's taken. And what I mean by that is whenever you construct a transmission line, generally there's an area of property, you refer to it as a corridor or right-of-way, that runs on the two sides of the transmission line. And one of the concerns that was raised with us was, well, what about compliance with Utah County's noise ordinance? And I will talk about in a minute that the proposed standards by the company would require full compliance with the noise ordinance at the lines. So at the edge of the lines, they would have to be in compliance with this ordinance. And you'll see in the chart, this comes from your ordinance, that is for residential zones, it's 50 in the hours of 10 p.m. to 7 a.m. and it's 55 from 7 a.m. to 10 p.m. So in other words, as proposed, the standard would require any transmission line 345 kV or larger at the edge of that line would have to be in compliance with that noise ordinance. So, and I'll show you the specific language we propose in a moment. Some have raised concerns about plant life or wildlife. That is addressed through a whole host of processes when you construct these. Most of those are required by other agencies, but just so that you are aware, these kinds of issues are addressed whenever you construct a transmission line, and often we're required and don't have the option of what requirements are imposed on the company when it constructs one of these lines. And I've talked about this briefly, but some have raised concerns about migratory birds or endangered wildlife. That is an issue we're required to comply with at a federal level and at the state level. So this is an issue that was not built into the ordinance standards, and it wasn't built in because it's preempted. The federal statutes and the state code already take and impose certain requirements, and so an ordinance here would not be able to supersede that. But they are embedded within what we do. So let's talk about the proposed standards. What staff raised with us is they wanted to see, and we had a good discussions about this. They wanted to see that if we were going to make this a permitted use but subject to standards, that there needed to be standards that ensured compliance with existing law, as well as that address notice issues and a few other things I'll talk about. So here under subsection 4 of the proposed change, you will see that any transmission line rated at 345 kV or above, so that lines below that are they're already permitted uses under your existing ordinance. So the reason this is addressing 345 and above is those are not currently permitted uses. Many jurisdictions in Utah, cities and counties, no longer require a conditional use permit for these projects. Rather, they are done in a different way. And in particular, in Utah County, most of the cities around you have this is a permitted use. So subsection 4A deals with the noise ordinance I just talked about. And what you will see there is that it requires that any transmission line that is constructed within the county would have to comply with the noise ordinance and the critical language here is at the edge of the transmission line right away. And so for purposes of that, we've referenced the county noise ordinance and also clarified that when a line runs through the middle of property, that your ordinance as it currently is drafted it measures the sound from a different location. So we've incorporated here that we're measuring from the edge of that right of way. So that's the noise issue. One of the issues that a number of people have raised as far as concerns, and staff raised this, is that they need to give notice to those residents whose property could be impacted by the construction of a line. And I want to be clear here, there is an existing Utah statute that talks about notice, but it is not always applicable. And it is not applicable, for example, on the line that many are commenting on in their public comments. That's true because in Title 54, Section 18, there is an exemption that says when a line is subject to federal permitting, the Utah statute does not comply because the federal permitting supersedes the Utah law in that instance. And so what we would be doing here is actually be providing notice or being required to provide notice in every situation, whether it's federally permitted or not. So the protection provided here is more, not less, than what is existing in the current under the current code. So what this requires is, as the staff noted, is for a landowner within 300 feet of the transmission line, any utility doing this kind of line would have to give notice 90 days in advance of the project, and subsection 2 there provides what the minimum information would be that would be required to be included in the notice. And you'll note there I have a takeaway at the bottom. The point here is that in every instance, 90 days before property was sought to be acquired for a transmission line project, there would have to be a notice that goes out to all landowners that could be impacted by that project. Additional issues that were addressed and discussed with staff. One concern that was raised was, what about attempts to minimize the visual impact? What about glare from steel poles, or what about other aspects of that might impact the visual field when these are built? And that what this states is, to the extent reasonably feasible, transmission facilities shall be designed and constructed to implement measures to minimize visual impacts, including the use of non-glare materials. And the reason that we say to the extent reasonably feasible is there's only certain things you can do and still have the line function properly. And so a utility operator would be required to make efforts to minimize the visual impact without impacting the ability of the line to operate or without requiring something that is just not feasible. Then there's a compliance requirement here, which is all-encompassing. It states that design, construction, and operation of transmission lines shall comply with all applicable state and federal requirements. That was incorporated so that you could have assurance that even though you don't have jurisdiction over some of those state and federal issues, before a project could be built in the county, it would be fully compliant, or the applicant would have to demonstrate, or the project developer would have to demonstrate that they're in compliance with state and federal law, so that is not at issue. And then as far as the location of the lines, we've included a standard here which came at staff's request, and we've incorporated that where feasible, given federal, state, and local requirements, the line would be encouraged to follow the location priority order below. And so I want to address one issue there, which is, we are not always in control of the location of a line. And an example of that might be where a line is federally permitted, we often have to go in front of the BLM, and the BLM doesn't give you an option. They'll say, after doing their studies, they'll say, here's where you have to build the line. So we don't always have the ability to move lines in ways that we would like, or that landowners would like, because we are subject to requirements that we just can't change. So that's the reason that language is incorporated there. But the point here would be that there would be an effort made subject to those other state, federal, and local requirements, that first of all, the line an attempt would be made to locate the line in an existing right-of-way, right? If they've already got lines running someplace, can we put another one there without causing a problem? Adjacent to railroads or planned freeway routes, that is almost always considered, because frankly, it's a lot easier and cheaper than going and having to try to condemn private land for that purpose. And so that's number two. And then along or adjacent to arterial or collector streets, again, a good thing to incorporate. And then to the extent possible within adjacent to industrial, commercial, agricultural, or non-residential zoning districts, and then within residential zoning districts. In other words, everything should be considered before you get to a residential option. And so the takeaway there is, to the extent feasible, the ordinances we've proposed, or the amendment as we've proposed to the ordinance, would incorporate all of these protections, and would require the assurance also that all state and federal requirements have been complied with. Before I go too far here, I just want to point out, we tried to look and just get a sense. I think these standards would be the most strict standards of any county within the state of Utah. So some have suggested, or I've heard suggested, that this is not that big a deal. It actually is. This is a very strict standard and would impose lots of requirements that don't exist today in the law. And for our part, we've worked with staff, I think, in a very productive way to try and come up with something that makes sense but is also workable. Lastly, I just want to address the issue about the conditional use permit, and I appreciate staff clarifying that this is, that the county is moving in that direction. For decades, we have constructed facilities within Utah County and have always complied with the conditional use permit process. And so there's nothing wrong with that, or hasn't been, but there was a change made in May of 2025 by Utah County that made it difficult, if not very difficult, for utilities, not just power companies, but any utility, to construct facilities on land within the county. And that is because the ordinance as it was amended required the owner's approval for the application to be filed. Now, you can imagine how, in many instances, that's fine. But in instances where an individual doesn't like that a facility is crossing their property, they won't sign the application, and you're stuck without an option other than options that are not ideal to consider, such as going and taking the property entirely so you avoid that. That just is not it's not the preferred solution, because you can often take much less through an easement than you can if you have to secure more property. It's also not an ideal solution because you may, through the process of what used to be the conditional use permit process, there are changes that can be made and things that can be moved. But if you have gone and required property to be taken first, or you require a lawsuit to proceed first, then you may be doing that unnecessarily if you decide to move it. So we think it's much better to look at this on the front end than on the back end. And the standards we're proposing would do that. They would require, before a line is built and while the line is being constructed, to meet all of these standards that are proposed to you with our application. So I want to end with just, I think this is a real positive for Utah County. We're not here tonight talking about any particular facility. We're talking about an ordinance for all future facilities before you. And I know a lot of people want to seize on a particular project. This is not about a project. This is about all future projects going forward, and how, given current Utah County ordinances, you can deal with facilities of this kind and deal with how they get processed and how they get constructed within the county. So the standards would require the highest requirements of any county that we could find in the state, and often for many unincorporated areas, they don't have standards like this at all. It's much more freewheeling. So I thank you for your time, and if you have questions, be happy to address those now. And if there are questions I can't address, again, I'll bring up somebody who's much smarter than me. So,
are there any questions for the applicant from the commissioners?
You mentioned all these standards that you have, like NEPA and all that. Have you already done all those for this particular project, or where are you at on that?
All of those would have to be complied with before before construction could occur, generally. I think I'm stating that correctly. And so either they've been done or they would be done. They'd have to be done before a line was constructed. Yes.
So you don't know if you've got an okay on NEPA yet?
No. It's in process right now.
In process. Okay. Thank you.
And I guess I would just for clarification there, that they're suggesting a text amendment change, so they're not talking about a specific project right now. They're talking about, right? So,
thank you.
Any further questions for the applicant?
I have some. Actually, wonder if we could pull the slides back up. I had a few questions about a couple of slides. Back on the written notice.
This one?
Yeah.
Mm-hmm.
How is verification done for this? Well, first of all, what kind of written notice would be required, and how would it be verified that it was done?
So, good question. The written notice in subsection 2 there, that shows the minimum contents. In reality, you often get more information than that, but we would have to identify the name and address for the applicant. That would be, in our case, the company. There would be a name, telephone number, email address of the contact person for the applicant. There would need to be directions, including the web page address for the specific project website, if that exists, and then instructions for the submission of public comments and information if there's going to be public meetings, those would have to be identified in the public notice, and then the time, date, and location of any public workshops, to the extent those are held, would also be included in the notice. As far as verification, I can't speak to how every utility does it. What I can say is, from our perspective, We have to literally go out and identify every single property by parcel and find out who the owner is, find out their contact information, and deliver the notice to them, either in person or through the mail, one or the other.
Right. I guess that's where my concern is, because there has been concern about notification given in the past, and I'm just wanting to have some kind of do we know, and maybe this is a question for staff, is there a way to verify that written notice, and who would be responsible for that verification process?
So with this being a potential standard in our ordinance, we would verify the list that the applicant would provide to us that they meet this requirement. We would we do this already for conditional uses. This is probably a little more strict than conditional uses. That only requires adjacent, and this is within 300 feet, which could be more than adjacent. But we would generate our own property list and make sure that what we feel meets this requirement has been also provided and met by an applicant. We would also require a copy of the written notice that was submitted and their method of distributing that.
So the county would be responsible for verifying that written notice had gone out.
Yes, if it is a requirement of our ordinance, we would.
Okay. Next question on where you had a list of the order.
E, I think, is what you're talking about.
Perfect. I guess that's another question of who verifies that those were done in order. Is that also the county that verifies that first was tried rights of way, then railroads, freeway lines?
Yes, I think so. I think we would potentially receive an application, and an application that it cuts through a residential zone. We would require an applicant to submit justification and their reasoning as to why they did not, or it was unfeasible to meet those other requirements, and make a determination at that point.
Okay. Another question on one of the slides, you mentioned that in May 2025 that the ordinance was amended. And again, I'm not sure if this is best aimed at the staff or what, but I'm trying to remember what that ordinance change was and what the reasoning behind it was. Can I get more information on that?
Let me turn on my mic. I believe this is referencing, so previously in our ordinance, we did not have a specific requirement that a property owner sign the conditional use application. Our attorney's office recognized that there was a requirement in state statute for any land use application to be filed by a consenting property owner. So that was problematic for our ordinance. I think it's problematic for any ordinance in the state that doesn't that used to have it the way we did. And so at the recommendation of our county attorney's office, we amended the ordinance to require a conditional use application to be signed by a property owner.
Okay.
So I think that's what we're talking about specifically as it relates to this slide and the challenge that was referenced by the applicant.
And if I could, that makes a lot of sense where the applicant wants to get the conditional use permit, which is often what you are dealing with, is somebody coming in saying, I want to change the use on my property, or I want to do something that's not currently permitted. That makes a ton of sense there. As applied to utilities, it's really a challenging issue because most often if you think about the way a development is constructed, that happens sometimes before people have even bought their homes. You'll have utilities needing to come in and put up facilities and things of that nature. And so for us to come to the county and say, we need to put these facilities in, historically that was fine because we could apply directly. And with the change, it just doesn't allow for that and creates a cumbersome process where a utility often cannot secure that, or it's not even an option to secure that at the time that facilities are being constructed.
Just to finish that, and the staff doesn't disagree with that. They recognize the challenge that creates for these type of conditional uses that are spanning, multiple parcels and the nature of this type of project. That requirement is really tailored at a single property with an owner participating or at least consenting. So.
Would it be, just throwing out ideas that come to my mind at the moment, would it be another potential option would be to exempt utilities from that requirement?
That was considered a little bit. I think that could be problematic with state code. I'll defer to Mr. Ayer, but there is a requirement, a companion requirement in state code that requires a land use application to be signed by the owner. It's pretty much that direct.
Okay. No further questions at this time.
Okay.
Yes, please.
I'm just curious, what if staff wanted you to, when I'm at home and I get a public notice, I mean, half the time I don't even understand it. I read it and I think, does this apply to me? And what do I do? And it's if you call this number, and it's just not really conducive to finding out what's happening. What would happen if staff wanted you to meet as part of this public notice to actually have an open house where you attended and were there, and not a public meeting like this, but just like some tables set up where you could show people maybe some charts and graphs, what your proposal is, who it affects, so they could then talk to you personally one-on-one, maybe have a staff member there present. People could write things down and be given to the county commissioners for their input. I just wonder if there wouldn't be better facilitation of communication if there was some kind of open house, and would that be something that you'd be okay with, or I don't know. I mean, could that be part of an ordinance, or would you not want to do that?
I can't. I would have to discuss this, but I mean, I would just say for this kind of a project, this large of a project, I think those automatically are built into our process. I don't know if that's true of other businesses, but I think we generally, if not always, do that for the exact reason you're talking about. That allows for a letter or public comment doesn't often allow for the give and take,
right,
where you've got questions that are being posed. So, I mean, that doesn't seem unreasonable to me, but I'd have to get a better sense for what that involves. Yeah, well, we're okay with it.
Yeah.
So yes, that makes sense.
I couldn't tell if it was part of the proposed ordinance or not, but it's just a thought that I think those kind of meetings are really helpful when you can talk to people in person, one-on-one, show them pictures, show them maps, and communicate, and you can listen to their input. They can listen to your concerns.
Yeah.
I just think that's a better way to communicate with the residences versus just a notice. We're coming through,
I think that makes good sense. And
So
as I just said, we don't have any problem
I
with
was
that.
curious, yeah.
Yeah, for my part, I can see how the give and take is beneficial because sometimes landowners or individuals have questions that are specific to their property, not necessarily about the project generally. And so those are easier to deal with in that kind of conversation than they are in a letter form. So
And they may have some information you haven't thought of.
yeah, right.
And you want to get that information.
Yep.
And you may have information they haven't thought of. So I just think that anything you can do to facilitate that. Now, another question, and I'm really dumb about this stuff, so I apologize. Everybody's going to look at me like we all know this, so I'm sorry, but I don't. Is there any possibility for these high-powered lines to be buried? Is that just not an option?
So it's complicated, but let me do my best to break it down into pieces. So public utilities operate under the direction of the Utah Public Service Commission. The Utah Public Service Commission will only allow the construction and recovery of those costs if they are deemed reasonable. And prudent is the word that they use there. Most often, undergrounding, where it happens because there are really particular reasons, because it's so expensive. So if you think about undergrounding a 100 or 200 mile line, what you're literally doing is digging a big deep hole, putting it into a protected casing and running that line underground. It's many times more expensive to do that than it is to, and so you'll often see undergrounding in areas where there's high fire risk or where there is other public facilities that would be interfered with or things like that. So, yeah.
Let me give you an example. I went out today and drove around and looked at a bunch of different power lines and stuff. And by my home, not right next to my home, but I drive through the area of Leland, and you have put up like these huge brown poles about every 100 feet. And as I looked down that road, I literally created this wall of pipes. And and some of them were going right over homes. And I just, these poor people, I would hate to have a power line go over my backyard or over the homes. They were right there. And it really, Leland is such a cute little community. And it just kind of made me sad to see these massive, and they're going to be painted, I know, but right now they're rust brown. And it's very difficult. And that section right there, for those few homes, might be a quarter of a mile. And I thought, can't we figure out ways when there's that many homes that'll maybe bury it just not 200 miles, but like a quarter of a mile, and then pop back up where the homes stop or something, just to kind of help. No. I'm just wondering. I'm just trying to educate myself and understand that.
Yeah, it's a fair point, and let me just say, for every line, there's 100 different opinions, and where you have a line built over the top of a house, that's highly unusual. And so that would only happen where the safety code would be fully complied with and the landowner wanted that. So we would normally try, when you build a corridor, you either take an easement, right, or you have to take the land itself and pay for it, either way. So, for example, we often will have commercial owners who will say, please don't build it where you're going to build it, move it closer to my building because then I can use my property more fully. So these kinds of issues have to be addressed almost on a property by property basis. And before any line is constructed, there is a huge amount of work that goes into routing. Routing takes into account all sorts of land issues and environmental issues and federal requirements and state requirements. And so we don't always have the luxury of just moving things exactly how we want. And sometimes landowners request that we move them in a different way. And so, this much I can say is I've worked for the company for many years, and they make a very diligent effort to try to avoid causing problems with landowners. You can't always avoid that because sometimes a line has to run in a certain place for various reasons. But I hear you, and I think it's certainly a legitimate concern, and that's why in the ordinance there is the priority built into the language.
Yeah, I understand that priority, but there's no enforcement. I mean, if it's cheaper, whatever's cheaper, you're going to do. If someone says we could go around 200 miles and not go any houses, of course it's going to cost you a lot more money, and that's not reasonable because it's more expensive. I understand that, and I appreciate that.
Let me just correct you on that. I don't think that's actually true. I think that in some instances, you can go around and the Public Service Commission will approve that, or the federal government will approve that. But we have to run those often by them and get their approval in order to do that. Sometimes the cost is so much more that it's not that we can't even justify it, and nobody will approve that. So you take into account all of those issues when you build this kind of line.
I guess some of my concern is I don't like conditional uses. I think they give false hope. I think they create lawsuits. I think conditional uses, the county is trying to go away from them, and I totally think that's the way to go. But I'm a little concerned that this ordinance has so few standards in it. If you take away conditional use, then you have to put standards in. For example, I'm a farmer. If I had a pivot on 160 acres and a power line went right through the middle of my piece, it would ruin my pivot. I could only do half. So I'd want the power lines if they came through to go on the property line, on the fence line of my farm, so that I can keep doing wheel lines or pivots or however I water. There are some issues where there are no standards here, and my worry is because there are very few standards. We have a noise standard, but there are so few standards that I worry that, and I don't know that you do this on purpose, but you could run a little roughshod over some of the farmers and the citizens because there are no standards and there's no conditional use. So I agree that we need to get rid of the conditional use, but I do think we need some standards to protect some of the citizens and some of the farmers in a way that, and I understand it's a balance. I remember when cell phone towers came out and everyone's getting on their phone saying, we're against this cell phone tower. And I'm going, come on, you're on your cell phone. You got to have a tower. And we got to have electricity. I understand that. And I've always appreciated Rocky Mountain. You're awesome. I just wish there was some more standards that I would feel more comfortable with. That's all. I don't know. I'm a little uncomfortable with it's a little bit, and I'm a kind of a guy. So
I think it's helpful, but let me just make clear: your current ordinances do not impose more strict standards than this. The CUP process does not impose more strict requirements than this. If anything, this requires more strict requirements than what you currently do.
That's true.
Yeah.
But now we have an opportunity. If that was a lousy ordinance, it doesn't mean we have to continue with a lousy ordinance. We have a chance now to maybe put some things in that might help everyone. You included. I don't know. This is our opportunity to look at the ordinance, not the project. That's not before us, and say, what can we do to balance this interest between Rocky Mountain, who we all need and love Rocky Mountain, and the citizens who live here, and what's the balance, and maybe some standards to help that balance. That's all I'm saying.
Understood. Yeah. Thank
I'll
you.
shut up now.
No, I appreciate it.
I have a question about the 90 days is prior to seeking the right of way. So that's after a permit's issued, or so. When does that take place?
Not necessarily. The reason that was selected was your permitting time changes depending on who you're in front of and what's going on in that permitting process. And so we didn't feel comfortable when we talked with staff about putting the 90 days off of some particular permit, because that might mean you don't get the 90 days to the landowner before their property would be at issue. So that's the reason that was proposed, is you just have a whole host of permitting timeframes that change, and there isn't one that will always necessarily be applicable for every single line. So you may not have issues of Navajo issues, or you may not. So if you pick, the trick there is what permitting period would you pick to have the notice triggered off of? That's where it gets tricky.
But I guess, what is the process of seeking a right of way? What starts and ends that?
Great question. So the typical standard for us, I again can't speak for every utility, but what typically happens is that you would send the notice to the landowner, and then you'd set up a time to actually meet with the landowner. Usually that's a in-person meeting at their home, talking about the project, talking about where the land would be impacted, and whether there could be changes made because the landowner has particular concerns, like a sprinkler system on their farm. Those things are issues that are often discussed with landowners to try and have the least impact possible for various reasons. One, because you want to impact their property the least you can, but also cost. You're required to pay for any easement you take. So if you can move it to a place where the landowner is less concerned, or where less valuable land or something like that, there are efforts made to accommodate that. Once you've met with the landowner, if you've reached an agreement that can be done, then that's documented and resolved in that fashion. If the landowner is not in agreement with that, you continue to work, and the state has a process through which you have to follow if the landowner is not willing to negotiate something.
So after describing all that, what is that after a permit that you go and reach out to the landowner, or before the permit? You're going to submit a permit, right? Because we're saying we're going to switch. We're switching this activity from conditional use to permitted use, but you still have to get a permit, right?
So some permits, it depends on what you're talking about. Yes, some permits would be acquired before you would go and talk to an owner, and sometimes they'd be in process while you're having discussions.
Mm-hmm.
So from staff, they would be required to get a zoning compliance permit to make sure that they meet any zoning requirements, as this is a zoning ordinance, in order to apply for that, they'd have to show that they either had property owner consent or the property owner would have to sign the application. So they would have to have talked to the property owner prior to submitting that zoning compliance permit, which means that that would be prior to that noticing requirement would be triggered prior to any application being submitted as far as the zoning application.
So I just trying to, I'm trying to put this together. So there's 300 feet perimeter around this right of way you're seeking.
Mhm.
And so then before you go out and meet with that landowner, 90 days ahead of that, you send notice to anyone within 300 feet of that.
Correct. Yes.
Is that how I understand it? Okay.
One question associated with that, as I'm just looking over this again, the notification is for anybody within 300 feet, but I noticed that the proposal, at least that I have here, crosses out a previous line that says transmission lines shall be located no less than 135 linear feet from any existing dwelling.
The staff proposed that, and it was based upon their understanding of what distance you'd have to be to comply with the noise ordinance. It's going to change line to line. So what we did is we took that out and made sure that the language says you have to comply by the edge of the right-of-way with the noise ordinance. So whatever the distance is, if it's less or more, you have to comply at that edge. So that's why that change was made.
And so if you have a noisy line, you're going to have to get a larger right-of-way security.
Or there are things they can do on a line. You can apply different technology on a line area that might be noisy because of weather or wind or other issues that might be going on. So oftentimes the utility will have to address that issue with segments that are particularly noisy would have to have an additional mitigation measures applied to that section to make it comply. Yes.
So just back to the notice just one more time. So possibly you're notifying the person you're going to visit. I assume they're within the 300 feet, and then just maybe other neighbors nearby or something along those lines.
Anybody, as proposed, it's anybody within 300 feet of that line, so that whether their land would be proposed to have an easement across it or not, if they're within that window, they get notice, so they have an opportunity to comment.
And but I guess my question is the way it's written. Can you do 5 feet at a time?
I'm not sure I understand.
As you go along the path, can you just make this a multi-day event where you notice? You have to give a full mile's worth of area as a right-of-way that you're seeking, and that way you have to notify everyone on that path of 1 mile so that they know that you're seeking that right-of-way. Or is it just like every 5? You can pick and choose along the way who you notice, and so it's kind of quietly notified.
No, I don't think. I think this works within the acquisition of the right-of-way in the county. Mm-hmm. So it's not for a particular piece of property. If you look at the language, it's in the county. So if we're going to be proposing a line in the county and seeking a zoning permit, once we start that process of trying to address property issues, that notice goes out to everybody along
the path.
Correct.
All at once.
Yes.
Okay, that's kind of what I wanted to get at within the 300 feet and just how that would be administered. Okay.
So a little clarity on the 300 feet. Is that 300 feet from center line of right-of-way or edge of right-of-way?
I think
that's a huge difference.
I'm trying to find the language in the top there. I think it says from the
transmission
line.
So that's center of right-of-way.
I think I'd just say it's from wherever the transmission line is. You're going to have a line on the outskirts. I mean, usually these things are 50 to 60 feet, 65 feet, something like that on each side of a pole. Sometimes I'm not the engineer. What's that?
The right-of-way, maybe. The lines don't hang out 65 feet from the pole.
No, that's what I'm saying, right. Yeah. So you're actually going to have, from center line. So what's the width we're normally dealing with on arms? It varies? Center line. It's from center line of the structure. So the structures vary in width, but generally for this big of a line you're talking about, but that's going to go out quite a ways.
So typically 120, 125 foot right away, I think, is what some of these lines have. So
Yeah.
you've already consumed about half of that 300 feet. You know,
Well, that's full distance. That's not half. So remember, if you're going from center line out 300 feet, you're consuming something like 60 feet perhaps, which sometimes people do have property right in that area and sometimes they don't. But yeah, you're right.
back to the comment about houses under power lines. I kind of pulled this out, and I'm sure you're probably not familiar with it, but about 1100 north in Orem, there's a corridor there running east and west, and those lines, for the most part, well, there's a lot of them that are almost directly above homes.
Mhm.
Some of the poles are only about 17 feet from the homes. And I don't
Mhm.
think it's as big a line as we're talking about here. But again, how did something like that happen?
So it depends on what kind of line we're talking about. A distribution line is a smaller line that you would normally see in a neighborhood. So if
So
you
these are I think I can't remember how many years ago, but Rocky Mountain Power had to go in. They were on wood poles. They had to go put in new poles and extend the height of the line. So they're transmission lines.
Yeah, it could be like a 128 kV line or something like that, which to get power to your neighborhood, you have to have a larger line that brings it to the distribution lines and then spreads it over the distribution lines. So I haven't in my neighborhood. I live in Lehigh. My neighborhood has a transmission line that runs up our road to our neighborhood, and then it goes to a distribution line. So how did it get there? It got there because there was a routing decision made based upon a whole host of factors. It wasn't arbitrary. It was usually studied for many years before that line got built. And either it has to be there for various reasons, or the landowners in some cases want it there instead of some other place. So you may not want it through the back part of your property. You may want it on the frontage road or part of the street. So that is a case-by-case basis, and I can't tell you exactly how that ended up that way, but it would have been after a significant amount of study and discussion with landowners.
So in those instances,
you need to come to the mic.
Sorry, John Hutchins, Rocky Mountain Power. The line was probably there before the home was built, and then the landowner decided to build the home underneath the line.
So another question about noises and stuff like that. Let's say the line gets put in, noises seem to be excessive. What does the typical small homeowner, how do they go about making Rocky Mountain Power address that?
Yeah, great question. And this goes back to somebody else's question about enforcement. These standards are enforceable by the county. So if a landowner had a problem saying this line's not meeting this noise ordinance, just like you do with any other noise violation in the county, somebody's late at night running their stereo, that can be addressed just as this can be addressed. And so I would expect staff would reach out to the company and say, hey, we have a landowner who believes that you're not complying with the noise ordinance. You need to come measure it, and then if it's having a problem, you need to address it. But the enforcement power exists at the county. Under these standards, I don't remember who said it, but that they're somehow not enforceable. They are enforceable. Your county would have the ability to make sure that any utility pursuing a project under this would be compliant with these requirements.
You'd take that on, Bryce?
Yeah, we actually have a little decibel meter in our office. We get complaints and we'll go out and measure and verify. If there's a complaint, then we'll address it. If there's a violation, we'll address it.
And I think there's a serious difference between a noisy neighbor and Rocky Mountain Power, who's a large conglomerate.
Sure, and it's good to hear that a potential applicant or a utility would be a partner in that and take some initiative there to get ahead of it. So before we have to get to sending violations.
You don't want somebody who's a landowner that's super unhappy, because then it just becomes an ongoing issue. You try to address it as quickly as you can. I mean, I just know that that's what utilities attempt to do. You can't always solve every problem, but you try to solve it, all the ones you can. So,
and I guess that's one of the things that, in my opinion, it seems like we're taking the opportunity for the public to address and talk about these things. I know of a power line down by the Utah Lake, and it's really noisy. But does the common homeowner know that they can reach out and complain about these noises? I personally, I've never heard of that.
I don't know the common, well, I can't speak for the common landowner because I don't, that's a big group. I think this is true of any city or any county. These noise ordinances exist statewide, and whether owners know or they don't, well, they can and should know that, but I don't know if they know that. Yes.
He's got a question.
Oh,
Yeah.
go ahead. Just a couple of engineering questions. As I go around the county, I see three different kinds of towers. I see the big steel ones. I see the wooden poles that are like 2 or 3, and then I see the kind that's like a lattice. There's 4 posts in the ground. They're all connected and together. It looks like a. Anyway, there's. Are we just talking about one of those 3, or are we talking about all of those, or is that part of what this? Because I see them across the desert, and we have some wooden ones behind my house, some big wooden poles along West Mountain. I'm just wondering what we're talking about. Are we talking about all of these, or are we going to limit any of those, or I don't know. I hate to see the web one because up a street because they're just like little substations,
Yeah.
But I don't know if you'd even use them here. I have no idea. So that's kind of an engineering question.
One thing you need to know is not every power line you see is Rocky Mountain Power. There are interstate transmission lines that are for other people, but
this ordinance would apply.
This ordinance would apply to every line that crosses that is constructed through your county beyond after the ordinance is in effect.
And then the next question is there a distance you have to have between poles? I just noticed in Leland, boy, those poles seem like 100 feet, and I thought, could you go 200 feet before you had another pole, or is those required by engineering, electrical?
Said they could go 300 feet a couple meetings ago.
Who's the right person to answer that? Okay. I don't know the answer to that question.
If you could have less poles, that would be good. That's all.
Come on up to the mic so that they can hear you and state your name. And
Nicole Kendall, I'm a transmission engineer with Rocky Mountain Power. So this line in particular, if we were talking about this line, the typical span is anywhere from 700 to 1,000 feet. Lines just depending on the type of construction. We've even spanned 4,500 feet across rivers. So it can be done. The ones you see where it's more every 100 feet or so, those are usually your typical distribution lines that are feeding your homes, because there's lots of services and other things that you have to tap off of. So there's lots of poles that kind of look like a picket fence. But the bigger ones, we try to span longer, so there's less structures, those type of things. Yeah.
Depends.
Okay, thank you.
Yeah, it really does.
To visual impact, sorry.
No.
Visual impact, it says including non-glare. So what other visual impacts would be required? I mean, you'd have to show evidence that you've tried to minimize the visual impact.
Yes.
It'd be the number of poles, the height, I don't know. This could be anything, not just glare, right?
It could be a number of things that could be considered, and we would have to work with county staff on that. Some things are required by engineering requirements, and so you can't eliminate those because you'd create an unsafe line. But within that, this allows a discussion to happen between staff and the utility about what can be done in this particular circumstance to minimize visual impacts.
Do you have any examples of things that you've done in the past to show that you've done reasonable? So reasonable is part of this, right? Reasonable design to minimize visual impacts. What are some examples of things that you've done to minimize visual impact?
I'll have Nicole come up again. So thank you, Nicole.
Of course. So you can do a doling process on the steel so it doesn't come out shiny. So that's one of the things you can do. The conductor itself, it's again with the actual manufacturing process, you can dole that too, so it is not shiny as well. So less structures. One thing to keep in mind is there are certain clearance requirements. So you do less structures, but they have to be taller because you have to meet so many feet of clearance to the ground, other obstacles, things like that. So less structures, but taller, or more structures and shorter. But those are some of the things we can do.
Are there more questions?
Yeah, I have a question.
Yeah.
So, and this is just because I have to have things kind of spelled out for me, a little more detail. So what, because, you know, obviously everybody here has a different lands, right? I mean, you guys have your lands who work. I have my lands. We all have a different lands. And so from your perspective, in terms of a conditional use approach, so what are the main barriers that you're running against with the conditional use approach? And then how does a permitted use approach reduce or, you know, make those better?
Well, so
And if you can literally spell those out, I would appreciate it.
well, first of all, I'd just say this is far more specific than you would have in a traditional conditional use permit. And I'll I mean, I think staff could comment more on this than I could, but under a conditional use permit approach, there's a lot less specificity about what do you have to do. There aren't specific that will apply across the board. Whereas for this purpose, because it's specific to transmission lines, it's very specific on requirements that wouldn't exist if you went through the CUP process. At least they're not written down that way. So what typically would happen during a CUP process is we would meet with staff, talk about the location, staff would raise concerns, and we'd try to work on solutions to that process. It was a give and take process, but far less specific requirement there, more of just sitting down and working through concerns or issues and how we address those. So I guess what I would say is this provides more specificity. It provides enforceable requirements. Under a CUP process, it was more a discussion with, there are some requirements. Certainly the noise ordinance was always in your ordinances before, but this addresses requirements specific to transmission lines where those don't exist under the CUP process. Is that helpful?
A little bit, yeah.
A little bit. Sorry. If there's something else,
I
you
guess
have a question.
I'm also mostly interested in terms of Rocky Mountain, when you want to put a project like this together, and it's clunky to do the conditional, and it sounds like that's getting, you have less of those issues in some counties, but in this particular county, you've run up against that. That's a barrier. You've run up against the conditional use barrier here. You're trying to change that to permitted use. So what are in particular the issues that make it so much harder in terms of like for Rocky Mountain that you're up against versus if it was just like permitted use that you're not running into other places?
Yeah, let me try it this way. And did you have a comment, John, you wanted to make?
Yeah, maybe I might be able to walk through this. So I'm John Hutchings, Rocky Mountain Power. So the conditional use permit ordinance in Utah County is, I think we talked about this, it's unique. It has that requirement that we get landowner consent. That doesn't exist in other counties. So in other county, and it didn't exist before May 2025 in this county. So for example, when we built Gateway South, which ran through Utah County and Wasatch County, the way that we worked with the counties to satisfy the conditional use permit requirements in those two counties was initially coming to the planning department before approaching landowners to discuss with the county the location of the line, some of these micro siting things, and then we would go seek approval of the line conditioned upon obtaining landowner consent. So then the company knew the location of the line, the requirements that the county was going to impose to construct the line. And then we would go out and we would seek landowner consent to build the line. And we can do it, whereas with the current Utah County ordinance, if we were to go out, the way it's structured is that we have to go out and seek landowner approval before we even come talk to the county to talk about these micro siting and other issues. And we think that that's not a good use of our resources. It's not a good use of landowner resources to go out and acquire the private property before we even know what the real issues are, before we even talk to the county. So that's the main hurdle. And I think the sort of the catalyst for why we sought to work with the county to make this a conditional use and at the same time impose requirements that we felt like were a good balance to work with the county on location of these lines and impose certain restrictions on the power company.
Yeah, and when I fly out of Provo and or either coming and going, and I do that often, one of the things to me that stands out is just all the agricultural land, and also open space, and depending on your lands, some people see that as like either land that we could utilize, or land, or open space values are important. We have a lot of people that come through here and want to put solar panels and whatnot, and so is that something unique to what you're, a barrier for you guys is just the impact that could have an ag use with the power lines going through.
It can be. And I think the way I'd explain it is when you're trying to develop a route for a transmission line, you have to take into account a whole host of factors. One of them might be, am I going through wetlands or not? Am I going through farmland or not? Am I going through residential neighborhoods or not? You can see how if you were going to be going through a neighborhood, you would like to try to avoid that. And so, often you try to find ways to not have to do that. So those are the kinds of factors you think about. So certainly one of those factors is open space. Certainly another of those factors is environmental issues or water resources or things like that. Those all have to be factored into routing decisions that take years to investigate and engineer around and permit. So
it seems like each project has very unique characteristics. And again, because I see Utah County or get on top of a mountain peak, you just see all the ag land out there, and so I worry a little bit about that in terms of something like this, that it would impact agricultural folks, and that's why I think a local review is really important, because I think that every situation is unique, and having a permitted use, then there's no detailed case by case review. At least it feels like that from from what I'm seeing, and then there's like no flexibility later, and it just seems like in terms of Utah County is unique. I think there's a lot of things that make it very special, and so that's probably something that does concern me in terms of how it impacts open space, and just the open space ethic, right? The view shed. And farmers, and it as it is already a pretty tough industry, and we want to keep our spaces open for agricultural use, and for them to be able to do what they have continued to do for decades. So
yeah, I appreciate that. And we don't, just to be clear, we had no problem with the CUP process that existed before that did allow us to go through that process. It just doesn't exist right now, and that was because of a change that we had nothing to do with. So as between the old process and what we're proposing here, I think you could argue either way, and I think I can see some of the benefit by that, but it's not available right now is the problem. That's just not even an option.
Any further questions, commissioners?
Okay, thank you very much.
Any comments from staff that we haven't heard yet? Okay. We are required to now to open a public hearing.
I move that we open the public hearing.
Second.
Been moved and seconded to open the public hearing. All in favor say aye.
Aye.
Any opposed? Okay, we are now in a public hearing. And so I would start by asking just some rules of engagement here. I think individuals, I think we do have a time limit of 3 minutes each. We have a clock that we're going to use tonight. So for individuals, we will have it counting down your time, and then it will beep when it gets to the end of 3 minutes. It is possible to have a group spokesperson for a group. I don't know if there's a minimum number of people in the group. Is it 3? At least 3? I think if you have 3 and you want to have a designated spokesperson, then I think we give that one individual who's representing 2 others at least 7 minutes to speak. So if you are representing a group, when you come up, please specify that that's the case, and we will give you the 7 minutes. But the other two then would not be permitted to speak. So we need to know who the other two are so that we can follow this rule. We also have, as part of our, do we have any other guidelines on hearing that I need to remind the group
I believe
about?
there's an encouragement to avoid repetition, try and, you can say, I agree with what's been said and try and stick to some
This is,
viewpoints.
thank you. I mean, this is a resolution that was passed by this body a few months back. And so we've tried to make this better, even though it may sound a little restrictive. But what we have, settled upon was that we really want to encourage to not repeat the same comment or concern or issue over and over and over. So if you're making the same and you want to just emphasize that, then just say, I just want to, ditto what the last guy said or whatever, and then end. Otherwise, you're just wasting time if you're just repeating again the same comment that was already made. So with that, when you do come up to the podium, we ask that you state your name, and there is a sign-in sheet. And we have to keep records of who spoke, and you will be on live television somehow. Streaming. But at any rate, we still want you to write your name while you're up here, if you wouldn't mind, for the record, and that'll help us and help staff keep good minutes that we'll have for the record. So if there's those who would like to address the commission through the public hearing, please make your way up to the podium.
Thank you for your time. If I seem nervous, I am very nervous because I'm furious. I've stood before you before and, said different things. And I appreciate the time that you guys take out away from your family. And
Mr. Chair, we need a name. We need to start with names, please.
my name is Steve Wilson. I'm a landowner of about 88 acres in the river bottoms.
Okay.
First, I want to say, again, thank you for your time. Second, I want to say the public notice system is broken. Whoever attended the first meeting, there were a lot more people than there are here right now. We never got notice. They said they sent them. They don't have to verify anything. Why don't you make it a requirement that they send them certified to every landowner so that they could prove that they sent them? We met with two representatives after we called them on our property August of last year. He told us he would come back with answers about where they're putting the lines. They are putting it down the dead center of our 88 acres. We have planned from day one when we bought this about almost 9 years ago, and signs on the property indicated we were going to break this up into 5 1/4, 5 1/2 acre lots. We have had reservations for every lot, and over that time, people have come and gone as we've worked through different issues. Their line will destroy the entire development. We've asked them to, why aren't you putting it down the edge on the river or another boundary? We were told we would get answers. We have not had one communication from your representatives through this whole process for the last 7 or 8 months. That's not fair to us. We have adjoining landowners right across the river from us, the exact same thing. They're splitting about 150 acres right down the middle. It ruins the potential of that property that him and his family have farmed for many, many years. It's not fair. And so I plead with you. We went over those things on the location priority, those 5 or 6 items. Look at the first 3 of those. They haven't met those. And they're not even willing to sit down with us as landowners and talk about those things. Each one of those. There's a corridor on Powerhouse Road already there. And they admitted in the earlier meeting that they had been in negotiations with the home builder, D.R. Horton, for approximately 2 years. Why didn't you put it down the natural corridor? You didn't do it. And now you're putting it down property, you split us in the middle and ruining it. And this is not a couple $100,000 deal. This is millions of dollars, that they're going to ruin 88 acres that we're entitled to develop. And so I plead with you, this isn't the time. They already have an avenue to take our property if they want to. Don't make it any easier on them. Make them go through the process that is intact right now. Thank you.
Hi, my name is Steve Vincent, and I'm with Steve Wilson. I want to address a couple of the issues that I saw up there. We're talking about conditional use versus permitted uses tonight. Just because other counties have gone their way and allowed it to become a permitted use doesn't mean that you need to. You are protecting your citizens by allowing it to be, by making it stay as a conditional use permit, because it takes leverage away from them. They already have deeper pockets than us. They already have the ability to squash us. And by giving them a permitted use and allowing them to get a permit, it takes away our leverage to get the value we need for our property and negotiating with them. It's super important that we can get value. If it's going to end up going through our property, it's going to end up going through our property. But by granting them permitted use, it takes away our ability to negotiate with them. They have not negotiated with us. When they found out what we were planning to do on this property, they went dark because they knew that it was going to be not a cheap piece of property for them. It was going to be expensive, but this changes our ability to get our value for that property. And we needed to stay a conditional use permit so that they have to negotiate with us in advance of getting permitted, not after, because it still gives us the leverage that we need to be able to fight them in getting the use. Everything Steve said was true. They can put this in a different location, but we're the little guy. We're not the big guy. We're not D.R. Horton with deep pockets that can fight them. So they're going through the little guy's property, and they're going to take it away from each one of us one at a time. We still need the power to be able to control that, and by granting it as a permitted use, you are weakening us in our position to do that. Thank you.
Well, if they sign after they speak, please.
Hi, so I'm actually a spokesperson. So actually, if you could reset the time to 7, I'll tell you the people and they can, yeah. I've got it right here. I can read them out for you. You can see them raise their hands if you would like, or however you want to do it.
Who's in your group?
All right, so Jeff Karchner, right there.
Okay.
Marilyn Karchner.
Okay.
And Angela Madsen.
All right.
So one extra.
Thank you.
Bonus. There you go.
Thank you. No, that's one less. One less to speak.
That's true, I guess. Bonus for you guys. So, great. All right. Good evening, commissioners. My name is Joseph Ibarra. I live in Salem Park, in the path of the proposed transmission line. I speak tonight on behalf of the Salem Park Residents and Wildlife Coalition, more than 40 families directly affected by this project. I want to begin with one fact that I believe is the single most important thing this commission should hear tonight. In August 2025, in this room, Rocky Mountain Power told you repeatedly on record that the legally required notices had been sent to affected landowners in Salem Park. In their own filing to the Utah Public Service Commission, Rocky Mountain Power has now admitted in writing, signed under threat of state sanction, that the 14-day newspaper notice was never published, and that the company did not provide them notice to the residents of Salem Park. They told you one thing in this room. They have admitted the opposite under oath in their own state filing. I want to set aside for the moment the question of whether that was deliberate. Assume the most charitable possible reading, that Rocky Mountain Power is simply a company that struggles with basic execution. Even on that most charitable reading, this commission should deny this amendment because, commissioners, a company that has admitted in writing that it failed to follow the most basic notice requirements in state law is not a company you reward by removing local oversight and that caught those failures. Let me put this proposal in actual context. This is not a regulatory reform. This is the same applicant whose conditional use permit fell apart in front of you 9 months ago. The same applicant who voted with its feet to withdraw its conditional use permit rather than defend it on its merits. The same applicant now is asking you to delete the rule that exposed those failures. Strip away the legal language, and this is all they're saying. They're saying, we couldn't meet the existing rules, so please change the rules for us. That is not what zoning amendments are for. Now, I want to talk about what you as commissioners are legally entitled to consider here tonight. I think you might actually know this, but there seems to be there has been some confusion, and I want to make sure it's clear. Tonight is not a conditional use permit hearing. Tonight is a public hearing on a proposed amendment to the Utah County Land Use Ordinance, and this is a legislative act. On a conditional use application, the law restricts what you can consider. Property value alone, viewshed alone, those are not grounds to deny a conditional use permit. That's correct. But this is not the proceeding you are in tonight. On a legislative amendment, on a zoning ordinance, Utah Code 1727A 102(1) and Section A tells you exactly what you may consider, and I want to read it to you. The purpose of a county's land use authority, that's you guys, is to provide for the health, safety, and welfare and promote the prosperity, improve the morals, peace and good order, comfort, convenience, and aesthetics of each county and its present and future inhabitants. That is the broadest possible language. Prosperity, that's property values. Welfare, that's EMF, that's wildlife, that's earthquake risk, that's fire risk. Aesthetics, that's viewshed. Comfort and convenience, that's noise. That's the basketball hoop arcing video that you should have seen before this meeting. The Utah Supreme Court has confirmed this distinction in Brady v. Payson City Corp. And in other cases, legislative acts are entitled to broad deference and may consider the full range of community welfare concerns. So when you hear from other speakers who follow me tonight about migratory birds, about earthquake risk, about EMF, about property values, about the videos of high voltage lines causing arcs in basketball hoops in someone's driveway, please understand that the law does not just permit you to consider what they tell you, the law directs you to consider it. So I want to spend another minute on what would actually be given up if you recommend approval tonight. The conditional use permit requirement is one sentence, but it triggers a cascade of protections that disappear the moment this is deleted. The public hearing itself disappears. The opportunity for affected residents to come before this commission and present evidence on a specific project and a specific impacts, that's gone. Just like you said, yeah, it takes, you have to look at stuff specifically in order to figure it out, and that goes away. The Commission's authority to impose site-specific conditions disappears. No setbacks, screening, undergrounding, mitigation tailored specific impacts for specific applications. It's all gone. The requirement to demonstrate that detrimental effects have been substantially mitigated disappears. The evidentiary record disappears. No public hearing means no record of testimony, no opportunity to test the applicant's claim under public scrutiny. That's all gone. State law notices are arguably gone too because with the conditional use permit, those are gone too. And in return for surrendering all of that, what does the community get? Gets nothing. Okay, so let's just watch really closely what has happened between within the last month. Okay. So what happenend last month in April? In the meeting that was, they took it out again, right, in April. The staff proposed standards, including 135-foot step back from any existing dwelling. That's already inadequate, but 135 feet is approximately the height of the tower itself, and the zoning administrator could reduce it whenever the line ran along the road, but at least it was a number, right? 5 days ago, Rocky Mountain Power's attorney filed a revised red line that strikes the 135-foot setback entirely. No setback, none, no protection. RMP now offers, is in place of, actually the only protection that it offers is a 90-day notice, right? The negotiation moved backwards every round. The applicant got more every round. The community lost, right? Why would this commission ever remove every meaningful regulation from an applicant that has been shown over and over again to be either dishonest or incompetent? There is no good answer to that question. In the next few minutes, you'll hear from more of the neighbors of Salem Park, each of whom will tell you about one specific category of impact: wildlife, earthquake, EMF, property values, undergrounding, noise. Every one of those is fairly within your legislative authority to exercise here tonight. Every one of those is something that the applicant would be free to ignore if this amendment passes. We respectfully ask this commission to recommend denial of the application. Thank you.
Thank you.
Right. Right. Good evening, Commissioners. My name is Rebecca Frost. I want to focus on how this proposal has degraded between the last hearing and tonight. In March, Rocky Mountain Power filed its original application. It asked to strike the conditional use permit requirement entirely. No replacement standards, just simply delete the public hearing. And in April, your staff proposed a counter red line. Staff added 5 standards, including that 135-foot setback from existing dwellings. That was already too small. A 130-foot setback from a 135-foot tower is not a buffer, it's simply a fall zone. Still, at least it was a number on a map. Then last week, on May 12th, Rocky Mountain Power filed a revised red line through Mayor Brown LLP. In that version, that 135-foot setback is entirely gone, struck out, deleted. Look at the proposal now. The setbacks from dwelling subsection is completely crossed out. In its place is simply the 90-day notice. The company will mail a letter to property owners 90 days before acquiring the right-of-way. That is not a setback. That is a postcard. Think carefully about this progression from March to April to May. The applicant's ask got more aggressive. The community got less protection. Yet, staff's response every time has been to simply approve. Commissioners, this is not how legislative reform works. When a community brings concerns, protection should get stronger, not weaker. You are being asked to ratify a negotiation that has been all takings and no givings. On behalf of a corporate applicant with international legal representation against a neighborhood with a Gmail address, we respectfully ask this commission to recommend denial of application 2026-02. Thank you.
Good evening, Commissioners. My name is Irene Ray. I live in Salem Park with my husband. I am a registered nurse and have worked for over 43 years in the field of women and children's health. I want to speak tonight about EMF, electromagnetic fields, and what it means to raise children adjacent to a 350,000 volt transmission line. The applicant's experts testified before the commission that EMF levels from this proposed line are not harmful. However, this testimony relies on ICNIRP and ICES exposure standards, which are short burst occupational standards. They apply to exposures lasting fractions of a second. Very different from families living in close proximity to this line, 24 hours a day, every day for decades. Not a short burst scenario. The scientific literature on chronic residential EMF exposure tells a different story. The study by Wertheimer and Leeper in the American Journal of Epidemiology links childhood leukemia to proximity of high voltage transmission lines. Decades of research has led most global and U.S. jurisdictions to establish precautionary distances. I am asking this commission to take a precautionary stance on behalf of children and families who have homes in a setting they believed safe. In Salem Park, we have more than 35 children under the age of 6 living within direct sight of the proposed transmission line. Yet the applicant's expert testimony was generic and did not provide specific studies to this particular site. Worse, the proposal in front of you tonight contains no EMF limit at all. None. The word EMF is entirely absent in the proposed standards. Commissioners, under the codes that you are charged with protecting the health and safety and welfare of Utah County inhabitants, a precautionary EMF limit, a 300-foot setback, or better, a presumption in favor of undergrounding near homes and schools is all within your legislative power. The applicant asks to give up these protections. Do not give these powers away. We respectfully ask this commission to recommend denial of application 2026-02.
Good evening. My name is Mary Ibarra, and I want to say first, I really appreciate all of you. It seems like you just have a really great perspective on everything you're thinking of us, and I appreciate that a lot. So I will say I am kind of piggybacking on the EMF debate. I think that it would be really wise for you guys. I mean, you had talked about having more strict conditions, and including something about setbacks would be so beneficial to our children. So it does, in this document that I have, that it shows the findings from the World Health Organization, the International Agency for Research on Cancer, and 12 institutions from the European Union, as well as like other other studies that have shown a connection to childhood leukemia with long-term exposure to high voltage power lines. So it's the chronic exposure to magnetic fields above 4 milligauss significantly increases the risk of childhood leukemia. The WHO classifies high voltage power line as a possible human carcinogen, and that's the same category as lead. Their exact words are, "The evidence is sufficiently strong to remain a concern." So at 300 feet from a 345 kilovolt line, the magnetic field is still 3 to 4 milligauss, so still at the leukemia threshold. So you don't really reach the precautionary safe level until 400 to 500 feet. So we're asking that you consider one of the conditions being a 500-foot setback to protect the children. I know that they have like the sound ordinance and the letter in the mail. It just doesn't seem like that at all considers the children. I actually have a friend who had leukemia from high voltage power lines in California. So it's real. It's a valid concern that several organizations have done studies on for decades. So something like that would be awesome to add into the conditions. So thank you.
Good evening, commissioners. My name is Garnet Kutter, and I want to speak about what flies, swims, and nests in the Salem Park wetlands.
Can you pull the mic down just a little bit there?
Okay.
Thank you.
And what federal law says about them. Several months ago, I sent you guys a PowerPoint about the wetlands, all the birds we have. And we have lots of people that come watch the birds that don't even live in our neighborhood. We have professors from universities that study the birds. And so in this PowerPoint I sent you, there's also the official U.S. Fish and Wildlife Service, so IPAC report for the project area, which is also a public document. The IPAC report confirms in this specific project area, like from February to September, it's a very sensitive area for all those birds. There's threatened species like the yellow-billed cuckoo and the Ute lady's tresses. Proposed endangered species like the monarch butterfly and the Seckley's cuckoo bumblebee. Of course, the eagles, we already have heard about them. We have the bald and the golden eagles that are confirmed present, right, flying over our homes and in the field where they want to start building. The Clean Water Act Section 404 overlaps federally ventured freshwater emergent wetlands under U.S. Army Corps jurisdiction. So there's 19 migratory birds of concerns they wrote on there. I'm not going to name them all. You can look in my PowerPoint. You will see every bird. Some birds were added because people put pictures in and they saw them with their own eyes. The Migratory Bird Treaty Act prohibits the unauthorized take or even including killing or selling or etc. of these species. Rocky Mountain Power has historically been fined millions of dollars for migratory bird deaths in other states, and I put all the stuff I have found. Yet look at the May 12 revision filed at RMP's attorneys. In the April version, the compliance requirements section explicitly mandated regulations related to threatened or endangered species, environment, and wetlands. In the May 12 revision, that entire section was struck out, crossed off, removed. This is not an accident. Under Utah Code Section 17-27A-102. I'm from Germany, so I read a little slower. You are charged with providing for health, safety, and welfare of Utah County. So we respectfully ask this commission to recommend denial of application 2026-02. Thank you.
Good evening. Good evening, commissioners. My name is Kevin Kuder, and I live in Salem Park. I'm here tonight because both the staff report and the applicant's revised standards completely failed to address a critical danger, and that is earthquake risk. According to the Utah Geological Survey, the Utah Seismic Safety Commission, and the Division of Emergency Management, the Wasatch Fault, one of the most active and dangerous fault systems in the western United States, is capable of producing magnitude 6.5 to 7.5 earthquakes. Salem Park sits near the Nephi segment. The Central Fault has a 350-year recurrence interval, and we're statistically overdue for that for a high magnitude earthquake. State mapping places our neighborhood in a high-risk zone for both severe ground shaking and liquefaction. Because we sit on wetland soils, a major quake will cause saturated ground to behave like a liquid. In a high liquefaction zone, 135-foot steel monopoles can lean, shear, or collapse. Yet this proposal allows a 345 kV transmission line with zero required setback from existing homes in a wetlands area and in a high liquefaction zone. If a tower fails, it falls in a yard or on a roof, or an energized line can arc into our neighborhood. Despite this, the applicant's standards require no site-specific geotechnical analysis and no liquefaction mitigation plan. They rely entirely on boilerplate compliance clauses like we're following state and federal regulations. You'll hear a little bit more about this later in more detail, but we have a precedent for this. In Chino Hills, California, they successfully compelled the utility to underground a comparable 500 kV line due to seismic activity and risks. It costs the taxpayers a mere $1.60 per month extra. Commissioners, under Utah Code 17-27A-102, safeguarding our community from these physical threats falls squarely within your mandate to protect health, safety, and welfare. You have the authority and the obligation to consider this. We respectfully ask the Commission to recommend denial of application 2026-02. Thank you.
Good evening. My name is Bryce Zundel. We own some property in the River Bottoms area, and we've been planning on developing it for a few years, and have had signs up, for sale, and have reservations on the property. And we met with a friend of ours, a neighbor, told us about Rocky Mountain Power putting these lines through, and it was a surprise to us. And so we contacted Rocky Mountain Power and met with two representatives at our property on August 13th of 2025. And on that day, they says, "Oh, we sent notices to everybody." We never received any notices, and we spoke to several of the neighbors. They never received any notices either. And so, it just felt like they weren't being truthful with us. And as we talked more with them, they says, "Oh, we'll keep in touch with you, and we'll see what we can do to move this line off your land." Well, that would be great. And again, we haven't heard anything since. And what's frustrating is yet they were in contact with the big home builders, D.R. Horton, for a year and a half. Why were they involved, and why weren't the small property owners? And it's difficult to hear those things, but there's already, they don't even follow their own standards, their own proposed standards within an existing transmission right-of-way. There's a transmission right-of-way right along Powerhouse Road. Why don't they follow that? That's already existing. I bet most of the property owners here would agree with these plans if they would just follow that existing line, because it wouldn't affect all of our property owners in the River Bottoms area. It's a beautiful area, and this will ruin every piece of property and going right through the middle of our property. Another issue that's been frustrating is on August 7th, I contacted our attorney and asked him if he would reach out to Rocky Mountain Power and see why they haven't been in contact with us. And our attorney spoke with Kevin Crowther at Rocky Mountain Power on April 15th, and Kevin told him, quote, that the project was on hold while Rocky Mountain Power works on additional studies required for several public land parcels. He also said they are working through the CUP process, which is very difficult, and doesn't think anything will happen in the next 6 months. He's been asked not to reach out to any of the property owners, and nothing is happening that might impact us. Yet 3 days later, I get a notice from a neighbor letting me know that the Planning Commission is meeting 5 days later. Six days after Kevin stated nothing was happening that would impact us regarding Rocky Mountain Power wanting to remove our rights through a text amendment. We continue to be lied to and told about the communication and things taking place, yet it doesn't happen. And, if they would just follow their own standards, keep the transmission line where it should have been. But I also ask that you will deny this proposal.
I don't know if he signed, but good evening, Commissioners. My name is Richard Ray. You heard from my wife, the nurse. I happen to be a retired CPA, and I'm going to go a little bit off of my menu or my comments here, in line with what Commissioner Sainsbury and what Commissioner Davis said. It sounds to me like the CUP program is working. There's a glitch related to electrical companies that needs to be fixed so that they don't have to buy property beforehand. But to completely change the system now, at this point in time with this application, it basically means that of all the hazards that this proposal could regulate concerning a 345 kilowatt transmission line that's going to run through our neighborhood, the only meaningful restriction that you'll be able to speak about is a noise restriction with a decimeter. That's it. The rest is based upon Rocky Mountain Power to deal with. You've all received, I'm hoping, a PowerPoint that talked about the corona, then how those that live within an area are subject to the corona from high power lines 24/7, not only from an EMF standpoint, but the noise. That particular bottomlands area is subject to fog and animals and water being there, and that makes the noise even go up higher than it normally is. In addition to that, in the video that you received, it talked about a high voltage transmission line that tied into a metal basketball hoop. And with not anybody using that kind of basketball hoop, or especially a child, I mean, they're going to be severely injured from that. To not have you looking at that and giving us the opportunity to have the special restrictions or the special things that happen in Utah County, because we are growing extremely fast here compared to the rest of the United States. And we need a commission like you to be able to oversee those like Rocky Mountain Power that we never received a notification that this was going on. We found out from our neighbors. We've never received a notification. And if there was a neighborhood meeting, I would assume we would be listened to and ignored. So I also would request that this commission deny application 26-02. Thank you. You can come up, I'll just sign it.
Sweet. My name is Bruce Jensen, I live in Salem Park. A few years ago, Rocky Mountain had the opportunity to do this the right way. When the development in Salem was dirt and we had huge corridors to run utilities, thus the name Powerhouse Road. It's not symbolic, it's actually what it's there for. They chose to partner with other big business and let D.L. Horton build their big residentials, and now houses are going up, and they chose to then take an existing neighborhoods that have been there for decades to now impact this instead. So what Rocky Mountain is asking you to do is to trust them and let Washington, D.C. and Salt Lake City know what's best for us, not you. You're our planning commission. You know us better. You know our area. That's why you exist. And that's why we don't handle these things at Salt Lake. And we definitely don't handle it in Washington, D.C. And although they have standards, those standards don't cover the uniqueness of what we are. We all moved to Salem for a reason. It was open. It was country. We had sightly. It was quiet. And we've been there. We're raising our family. We have investments, financial instruments in our houses. They're going to come in on what's the feasibly responsible thing to do for them, not for us. We'll take a 10 to 30% hit on our investment in our homes, while they can make a couple $1 billion more to make more power for the $1 billion data centers in Eagle Mountain. Currently over 7 million square feet, on plans to be over 14 million square feet. This is the need for the power line. It's not more residential, it's the big data centers in Eagle Mountain. Now, these companies can afford to pay more. Salem should not be, and especially where we should not be the ones asked to submit and to hold all the financial risk and impact to our neighborhoods so they can make more money, selling more money to billion-dollar tech companies in Eagle Mountain. But we're the ones in Utah County to be asked to do that. You're the only ones that can protect us from this. You're the only ones who can put standards and conditions in place that if they're going to do this, can bury it where our houses are. They don't have to bury 20 miles of it. They can bury where all the residential is. They can move it away from the houses. They can have the default lines. They can do all kinds of regulations that you can put in place that they have to honor. We already know that they say they will do it, and they've already demonstrated that they won't even communicate to us in a clear and timely manner, because they'll just do what's best on the feasible study for them, not for us. Yes, it will cost more to bury lines, to make it so our values don't go down 10 to 30%. So we don't have to hear the hum when it gets wet and humid. Wait, we're by a wetland where it's wet and humid. So this hum is wicked awesome. It's nice. 24/7, 365. We shouldn't have to put up with that. They can mitigate it and you can enforce it. So we ask you to continue doing your responsibility and hold your authority and deny this. Sorry, give me my name. Thank you for having me. My name is Matt Miller. It's hitting me. I had a prepared statement. I just want to add some at the beginning because some of the statements made today really hit me home for me. I'm a real estate appraiser by profession. I moved here. I was born here, lived most of my life in Southern California. I'm in my appraisal experience, as Kevin Cruder talked about in Chino Hills. That's actually an area that I was an appraiser in. There is liquefaction there. There are areas, and I had maps of zones on my wall, so I knew when I was appraising, exactly where we had to deal with those, because it is a very big liability, very real, both in property values, in safety, and in what engineering and what can be constructed in those areas. I say that because I feel like that is an area that is just being ignored here. In the time when we came last year and we presented our arguments for you, there was a brief discussion of undergrounding. I was appalled at the things that were shared because there were three different estimates on the costs that were given. One of them was 15 to 20 times the cost, and that it was infeasible because of the cost. That is not true. In Chino Hills, just over a decade ago, the cost that was sent on to the taxpayers was $1.60 a month additional. Of course, we don't want to add any additional costs on taxpayers, onto the rate share, those paying for their electricity. But $1.60 is inconsequential to the safety when you have an area of liquefaction like you do around Salem Park. We are in the middle of liquefaction area. Additionally, the road that goes in front of us that divides us in Spanish Fork is county land. And that's why they propose to go through that area. That road is going to serve a much greater, larger population. There is a mega project going into Salem in Woodland Hills. That development is going forward. Right now it's a 2-lane road, so it looks like there's room for it. It's a very narrow corridor. Eventually, that will need to be a 6-lane road in order to accommodate the traffic, to facilitate the mega projects and the facilities that are going there. There will not be room if you put power poles above ground there to expand that road. There will have to be an alternative route somewhere else that is not a feasible route. Thinking about those options now will allow us to not become California. And I hate to say it, I know it might sound like a dumb thing to say. We moved away from California because Utah is a beautiful, wonderful place. It is the reason after COVID, everyone wanted to move here, because you guys have made it a wonderful place to live, and we love it here, and we do not want to make this California. I'd like to just finish by saying, if they do not provide you with documented proof of the cost of undergrounding, you cannot approve that. We have documented proof from Chino Hills. I have spoken with their planning commissioner and several of their, the people on the board who were responsible at that time. It is a very minimal cost. It is not expensive to underground, at least in front of our development. Thank you.
Hi, I'm Candace Manoa. I live in Salem Park. And as was stated earlier, one of the lawful purposes of land use regulation is prosperity. Property values are one of the clearest measurements of community prosperity, and the evidence here matters. Independent appraisal studies on homes near a 345,000 volt transmission line consistently show property value losses ranging from 10 to 30%. In our neighborhood, that translates to roughly $70,000 to $140,000 per family. There are about 40 families directly affected in Salem Park. That means that this decision could strip somewhere between $9 and $18 million in home equity from residents in our community. These are not investment properties. These are family homes. People brought here for the views, the wetlands, the wildlife, the quiet, the schools, and because they trusted the protective rules that were in place when they purchased their homes. Some families are within a few years of paying off their mortgages. Many moved here knowing the existing ordinance required a public hearing before infrastructure of this scale could be placed in the neighborhood. But tonight, rules are being asked to change retroactively. without compensation, without site-specific analysis, and without a hearing on the actual project that would impact these homes. Meanwhile, Rocky Mountain Power reported earnings of approximately $1 billion in net income last year. This means that our community is being asked to absorb millions in personal financial harm so that $1 billion corporation can avoid the additional cost of undergrounding. This is not balance, and I would urge you to take into consideration that utility companies' jobs aren't to protect and preserve impact, but rather to provide utility at all costs. Under Utah law, you are allowed to consider prosperity, property values, and community character. We are asking you to do that exactly tonight. Please recommend denial of application 2026-02.
Good evening, commissioners. My name is Tasha Johansson. I also live in Salem Park. And this morning, as I stood and looked out my back kitchen window, I was reminded of why I chose Salem 9 years ago. Of anywhere that I could move in the state of Utah to be close to my children, I watched a field that is green and has, plants up maybe 3 feet high. And I watched it waving in the wind. And I was thankful to live in the middle of beautiful farmland. That's why I chose to be there. And then I remembered I get to come here tonight and remind you and request of you certain things that would protect my right and my choice. So I want to close tonight in representation of my neighbors and fellow Salem Park residents by being very clear about what this case is really about. Rocky Mountain Power failed to meet the rules already in place. This is no longer a claim. There are no accusations involved. It's part of a public record in a sworn filing to the Utah Public Service Commission. The company admitted the legally required notices were, quote, never published, and that residents of Salem Park, quote, did not receive notice. And instead of correcting those failures, which they could have done, or defending their original application on the merits, the company withdrew the application and came back asking you to remove the very rule that exposed the failure in the first place. This proposal has moved backward every step of the way. In April, the draft standards at least included a 135-foot setback from homes. 5 days ago, we've already mentioned, Rocky Mountain Power's attorneys removed even that. The only protection left is a 90-day mailed notice from the same company that already admitted it failed to properly notify residents and demonstrated some confusion about that 90-day window tonight. Tonight, you heard evidence about EMF exposure, near children, migratory birds in wetlands protected under federal law, earthquake liquefaction risk in Salem Park, noise of high voltage lines, and the devastating financial impact. And legally, you are allowed to consider every one of those concerns tonight. This is not a conditional use permit hearing. This is a legislative decision under Utah Code 17-27A-102 involving health, safety, welfare, prosperity, and aesthetics of this county. So we're asking you to do one simple thing tonight. Do not reward a company that failed to follow the existing rules by eliminating the only meaningful local oversight protecting this community. Thank you.
Good evening, and thank you for your time and thank you for what you do. My name is Aaron Anderson. I'm a resident and property owner in Utah County. I am here to speak in strong opposition to the proposed text of the conditional use permit to section 8.44A4 of the land use ordinance. The conditional use permit is not just an administrative step, it is our community's only formal venue for transparency. By reclassifying high voltage utility installations as permitted use, you are effectively stripping away the public's right to weigh in on projects that have a massive impact on our land, safety, and quality of life. High voltage lines are not inherently compatible with every zone. They require the specific mitigation and public oversight that only the CUP process provides. It is deeply troubling that this amendment is being considered following a utility provider's inability to secure a permit under our existing fair regulations. Land use rules should be based on long-term welfare of Utah County citizens, not rewritten to accommodate the convenience of a single corporation that finds the current standards difficult to satisfy. Upholding these standards protects us from irresponsible development. I respectfully urge this commission to stand by the current ordinance and deny this text amendment. Thank you for prioritizing the voices of Utah County residents over corporate interests. Thank you. One last thing I'd like to mention is I work in marketing. My job is to help companies, get word out and, have make a reaction to a product or service. Oftentimes, my day is spent looking at numbers and data and trying to find patterns, right? I would urge you to look at the pattern that has happened tonight. This gentleman stood up, the first guy that spoke, and he said, I've had issues, they didn't get back to me, and then suddenly we're having a hearing. That exact same pattern established itself organically by the second man who stood up, who was bald, saying the exact same thing. Now let's track back to the first hearing. They said they sent out the notices. I'm not going to go into that too much. And then they got caught lying again. So look at the pattern that is happening by the person who is saying, or the entity that is saying, trust us. Trust us with the public's well-being. Trust us that we have your best interest in heart. I urge you to look at the pattern, and thank you for your time.
I'd like to thank you guys for being here and listening to us, and listening to the thoughts that the community has, and taking that into consideration. It really means a lot, and your questions that you guys had to the power company show that you really care about this issue as well.
Sir, could you state your name,
Oh,
please?
sorry. Yeah, my name is Lane Adamson. I'm a landowner, farmer, and a resident here in Utah County. I'm asking you to keep this high voltage transmission lines under a conditional use permit. These lines, and specifically a 345 kilovolt line, have real and lasting impacts on productive farmland. Construction causes long-term soil compaction, and the lines create permanent restrictions on how we can farm around them. A 2025 study in Turkey that was published in the Journal of Water, Air, and Soil Pollution found that soil directly underneath high voltage power lines had significantly lower microbial biomass and reduced enzyme activity compared to soil sampled 300 meters away. A power line that wouldn't even sit on my property would cover all of my property in that 300 meters, and even onto my neighbors beyond me. The research documents clearly show the signs that the microbial stress in the soil closest to the lines. A conditional use permit allows the county to review each project individually and attach specific enforceable conditions, such as proper topsoil segregation and replacement, soil decompaction after construction, drainage tile repair, which I have one of those that cut through my property as well, makes it so I can farm. These meaningful setbacks from fields and homes and residents, and the construction of their timing in respects to planting and harvesting seasons. Changing these lines to a permitted use removes the case-by-case review and makes it much harder to protect farmers and rural landowners on this project and every future project.
If the county moves forward with this change, I strongly urge you to write clear and measurable articulable protections, agricultural protections, and standards directly into the ordinances now, including soil restoration requirements and adequate setbacks, rather than leaving them to voluntary measures later. Thank you.
Hi, thank you so much for your time tonight. My name is Kara Lewis. I am the business owner of Glen Ray's Corn Maze and Pumpkin Patch, and I'm also representing my dad, Rex Larson, who is the landowner of 1750 West, 8000 South in Spanish Fork. I'd like to reemphasize he's the landowner, not Rocky Mountain Power. I'm also representing the Utah Farm Bureau as a member of the agriculture or the agritourism committee, the state agritourism committee. We strongly oppose any amendment that would allow utility projects to bypass meaningful landowner involvement in decisions about private property. Property owners should not be excluded from the process and then only notified when condemnation is already underway. That is not transparency or due process. These conversations should not be happening behind closed doors. They should be public, transparent, and accountable, especially when the outcome permanently affects private land that families, farms, and local businesses depend on. I'm asking the Planning Commission to deny this ordinance amendment. A 340 kilovolt transmission corridor is not a minor utility line. It permanently changes how agricultural land functions, as the gentleman before me just mentioned. The conditional use permit process exists for a reason. It allows the county to evaluate site-specific impacts and require mitigation before the project cuts through working properties. Every property is different. Irrigation systems are different. We flood irrigate. You use a pivot. It's not the same. Just because it's agricultural land does not mean it's a blanket situation for everybody. And I think that's kind of what they're stating. We can just put it through ag land. It's just ag land. Drainage systems are different. Access patterns are different. You cannot assume compatibility without review. On our property at Glen Ray's Corn Maze, we have been told the impacts would include having to remove our animal shed. And also that the line would directly go overhead our main activity areas. Also, could it reduce our parking capacity and would no longer allow us to put up big signs along the main road to advertise our business. The proposed easement would also encroach on our drainage tile system in the field, and any future maintenance or work in those areas would be restricted due to the required setbacks around high voltage lines. These are not just minor inconveniences. They directly impact the safety, layout, and long-term viability of our operations. Now, we've been running this business for 9 years, and it brings significant sales tax revenue into the county, as well as seasonal economic activity that supports many other local businesses and provides temporary work to around 70 youth from our area and fall enjoyment to tens of thousands of county residents each fall. But we've been farming this land for over 50 years. Agriculture land is not just empty land waiting for utilities. It's actively used, carefully developed ground with infrastructure that cannot simply be removed without major consequences. Removing the conditional use permit process removes one of the only meaningful opportunities landowners have to address and mitigate these impacts before a corridor is approved. I respectfully ask that the Planning Commission to keep the conditional use permit requirement in place and deny the ordinance amendment. Thank you. Chair and Commissioners, my name is Jackie Larson, and I am the House Representative for District 64. I am here tonight in opposition to the application because I do not believe this amendment satisfies the standards required for a land use ordinance amendment under the Utah County Ordinance or Utah law. The county's ordinance requires consideration of the Utah County General Plan, the intent of the land use ordinance, the encouragement of the most appropriate use of land throughout the county, and no application should be approved when it is determined that the proposed amendment does not promote the health, safety, morals, convenience, or general welfare of the public, and if the proposed amendment does not avoid causing adverse conditions. This proposal fails those standards. First, the amendment conflicts directly with the declared intent and purpose of the RA5 residential agricultural zone. The RA5 ordinance states that an RA5, when it covers a portion of Utah County that has historically been irrigated and utilized for growing of crops and the raising of livestock, it includes that the area of the county where the combination of the soil quality, size of land parcel, availability of supply of water, and other natural and man-made factors make the land most appropriately suited for agricultural use. That statement directly addresses several of those required amendment considerations. The ordinance further states, although the main thrust of the RA5 zone is to protect farming industries, certain non-farm uses and residences on large lots enough to preclude conflict with the surrounding farms are allowed in the zone. So in other words, compatibility with agriculture is a governing principle of this zone. I'm going to scroll down. I'm going to skip because I'm running out of time. Okay. Jackie can have ours. I have like 3 people back there. Do you want me to just? I'm going to keep going. All right. So second, this amendment directly affects agricultural protection areas. Utah Code 17-81-302 states that the political subdivision may not change a zoning regulation affecting land within an ag protected area unless written approval is received from all affected APA landowners. But this amendment before you changes the zoning framework affecting APAs by converting entirely new 345 kV transmission corridors from a conditional use into a permitted use. That changes the level of review, mitigation authority, procedural protections, and oversight for infrastructure directly impacting agricultural land. To my knowledge, written consent from all affected APA landowners has not been obtained. Third, state law already specifically carves out high voltage transmission lines to be treated differently from ordinary utility infrastructure. Under the Siting of High Voltage Power Line Act in Title 54, Chapter 18, transmission lines of 230 kV and higher are subject to separate statutory framework with heightened notice requirements, public workshops, court review procedures, and conditional use permit filing requirements. It also specifically names conditional use permits. This application, here, I'm going to go down here, okay. This application moves in the opposite direction by attempting to reduce transparency and convert one of the most impactful infrastructure types into being permitted use in agricultural zones. We're getting to the good part now. So earlier today, I'm going to keep going. Okay. Earlier today, I spoke directly with Gary Witterberg, I believe is how you pronounce it. He's an administrator with the Utah Public Service Commission. He and the commission chair are meeting with me to further discuss and clarify these issues surrounding the transmission corridor policy, agricultural impacts, water infrastructure, local land use authority, and legislation that I am currently working on. The bill file I am working on is modeled after HB 16, which I was also involved with this legislative session. HB 16 does not transition from conditional uses to permitted uses. It explicitly requires conditional use permit, stacks additional permits on top of it, and requires detailed site plan disclosures before any of those permits can be issued. It also specifically requires disclosure and identification of ag protected areas, irrigation systems, drainage infrastructure, conveyance facilities, easements, and water-related infrastructure before approval.
Yeah, let me interrupt you. Yep. So if you are spokesperson for a group, I'd be glad to let you go to the 7 minutes. And so is there?
I have 3. All right, we got 3. Okay.
3 that have not and will not come to the podium, right?
Any names?
Yeah.
Names. Clay and Michelle Finch.
Okay.
Phil Manoa.
Phil Manoa.
Speak a little closer to the mic.
There you go. You want me closer to the mic? Yes. Okay.
Okay. Thank you.
Let me find where I was. Do you want me to keep going from there? Okay. Okay, so if the legislator intended to deregulate energy infrastructure on agricultural land, it would not simultaneously have enacted law specifically requires a conditional use permit stacked together with other permits and applications for energy projects on ag land. This matters because it shows that the legislator is moving toward greater disclosure, coordination, and scrutiny where productive farmland and agricultural water infrastructure are involved, not less. The state legislator that enacted SB 61 and HB 16 did not intend to give utilities a free pass at the county level. It intended the opposite. The responsibility of the legislative body is not to simply make projects easier, it's to protect the public interest and ensure that the ordinance changes promote the safety, welfare, and long-term interests of the people of this county and to protect property rights. That responsibility includes protecting productive agricultural land, irrigation systems, drainage infrastructure, water conveyance facilities, and ag communities that depend on them. This application before you tonight says no local scrutiny is required at all. Any line is a permitted use anywhere in the county, in any zone, on any agricultural land. Removing the conditional use permit does not remove its impacts. It only removes the transparent public processes where those impacts can be identified, reviewed, and conditioned and mitigated. One more thing, a public meeting and a public hearing are not the same thing. In state law, from the foundational siting statute through the most recent legislative session, consistently treats productive ag land as deserving heightened protection from energy infrastructure and treats the conditional use process as a mechanism by which local government provides that protection. For those reasons, I respectfully ask that you recommend denial of the application. Thank you.
Excuse me, there's a question for you, if you don't mind.
You're going really fast.
I set the timer.
I know. So you kind of went through really fast. Can you elaborate a little bit more about? You said you're currently working on.
I'm going to be opening a bill file more than likely tomorrow. I'm talking with legal tomorrow morning. So I have talked with several other legislators, House leadership and Senate, and the chair and several other legislators on the Public Utilities Committee. We have been talking about it for quite some time. I'm giving access tomorrow morning to be able to open bill files, and that's going to be the first one I'm going to do.
So what's it going to? What are you wanting to achieve?
So HB 16 that was just passed this last legislative session by Representative Colin Jack. He's the chair of the Public Utilities Interim Committee, and he's also an electrical engineer. It's structuring it basically the same way that there's going to be specifically laid out what permits are required, giving more transparency, more things are detailed and explained, so we actually know what's going to be mitigated and what's expected on both sides.
Okay, so it's sort of piggybacking off the HB 16?
Yeah, I'm essentially mimicking the same thing. Okay, anything else?
Yeah, I just since you mentioned you're in the legislature.
Yes, I am.
Okay, thank you. Great, thank you for your service there too.
Thank you for yours.
So seems to be like this. We changed the ordinance in reaction to a change in state law, or we were trying to be more in compliance with state law in requiring every landowner within a power transmission to sign consent before they can file for a conditional use permit. And I think I've already heard that that makes a lot of sense if there's one or two property owners involved, but when there's hundreds or thousands, it seems like we've made an impossible bar for them to pass. Now, impossible. I mean, it's only impossible to the price probably, but
I have the same
but the question is why have we made a law that's just so impossible to address that? That's why we're seeing all these suggestions.
Define the actual law because it doesn't exist. It does not exist. So what's the law? Let's find the actual law and read it right now because it doesn't exist.
I mean, I kind of was thinking the same thing that you guys are asking with what does the process entail between when they are going to cite it and they're going to actually condemn the property. I have worked with UDOT multiple times before on their NEPA process. With Rocky Mountain Power, it's been completely different, and I feel like it's not been as transparent. So if we can get if we need to have guardrails set up to where everybody knows what's expected, I think that's going to be in everybody's best interest.
Thank you.
Thanks, guys.
Sorry, I'm Jay Thomas. I'm a property owner on Powerhouse Road. The one thing that's interesting is they talk about how they have a problem with people coming in and building houses underneath their power lines. What they're trying to do is push these power lines in first. If we go down through Leland, like the commissioner said, all of a sudden you notice these power lines, but I mean, the people that lived near those, they had no input. They just showed up one day and they were there. And Spanish Fork is known for the wind of city. Why did they put the windmills there? Because that wind that comes out of that canyon is wicked. The wind that comes across that face of Salem is clocked at 55 and 60 miles an hour. I mean, those trees along that river, we sit there every year, watch the county pull those out. They're 125-foot trees, and the wind takes them. So even if their guidelines are that, those trees, if you walk along that trail system, that power line goes over the top of that trail, I think 2 or 3 times. And that sound, they're saying they can decrease the sound, by increases it by wind. Walk along that trail system when that wind's blowing, and again, I don't have the expertise of a lot of these people in this room. I have a different medical, degree, but I mean, we've lived there and we bought this property for our homes. We had the county approved lots in there for us, and then all of a sudden we see that there's a line going right over the top of where we're going to put our house, another house for one of my kids. So it seems like their solution and their concern of, trying to decrease the sound, they have no idea what that wind does up there. I mean, that's why they put the windmills there, because they provide power. So again, I appreciate your time, and I know you have a really hard job, and I know they have a hard job. But again, there's got to be a better solution, a better way of doing it. As all the people in this room have commented on, we've got houses that we're building right now, and you're putting a line right over the top of it. That we do it on a slower pace than Horton does, because we do it, as we go. But again, it's just like some of the other property owners in here. I mean, they bought these properties, and you're sticking a line, like Steve said, right through the middle. And if that was your property, you would have the same concern as the guy, the farmers and everybody else that's been trying to raise, and live on these properties. And we bought these years ago. Horton comes in and buys it in less than 6 months and is involved in things that we never were privy to. So I appreciate your time, though.
Sounds like the next time the wind blows, you need to call the county community development center and get their decimeter out there.
I can guarantee you I have a windmill that can show you what they are. I mean, anyone that's put a shed up behind me or around me, I can tell you if they didn't cement that thing down 5 feet, I can tell you where it's at. It's probably the top of the, Mapleton or somewhere going that way. Because, I mean, anyone that lives there can tell you that.
Thank you.
Yeah. I'm William Billington. I represent Red Summit Ranches out on Powerhouse Road, and I've talked to them. I've been to every meeting, and, this ordinance is working that we have, because if we didn't have it, you wouldn't hear all these people and their concerns. And most of these people here are older. We've worked our whole lives to build and give to our kids and our grandkids and everything else. And I think that's what we need to look at. Are we going to tell our grandkids that big corporations can come in and just walk over the lands that we built our families on and be able to hand down to our kids that can't afford a house now because we've made it impossible? I know we need the power, but there's another way. There's a way to go underground. I know it costs a lot of money. There's ways that someone said up high where, but their power lines going through 3 sections of our property. And 50 acres of it we ain't going to be able to use. It's useless. They're taking it right down the middle. We had plans of building 4 or 5 houses there for family members. But the system is working, I believe, unless you change it tonight. Because everybody here has a voice. My grandkids should have a voice. My kids should be able to have a voice. Don't take it away. Things have been taken away enough. And, it's nothing against you guys. It's just,
I am Paul Pryor, a Rebellion Bottoms landowner. Yes, we need power. Ben Franklin was in Europe, and he said, why do you have so many branches of governments? And he says, why did you take the tea from your cup, put it in the saucer, and then put it back in your cup to cool it off? If you do not have checks and balances, you ruin in our Pledge of Allegiance, liberty and justice for all. Okay? The term railroading should be electric sharing also. Okay? You need checks and balances. There are better places. And there are better options. Yes, you don't have power lines that are 125 feet and then can go over, come into a yard. You need setbacks. Visual pollution is costly. That needs to be figured in. You should go down existing utility corridors, such as Powerhouse Road. It already has the name. Give it the game. It already is named for powerhouse lines. These can be worked out. You don't need to take down whole beautiful new areas and ruin them. And the value is depreciated for many miles. A football stadium or more. Okay, you just can't buy a little 125 feet and pay them the money and say, yeah, we've given you just recourse. That's not the case. Anyway, don't give up your power. We need to cool down railroading or electric sharing. Okay, thank you.
My name's Aaron Hall. I live at Salem Park. I just have a question. I thank you guys. I thank my neighbors. I agree with everything that they're saying, and so I don't really have anything to expand on with that. But I have a question as far as these lines goes. 345 kilovolt line that's going to get passed down one side of a pole. And this is a big pole that can take power on both sides, in multiple areas. So what's to stop this pole in 1 year, 5 years, 10 years from becoming 690 volt power pole? What's to change, once this pole already exists, what's to say that, when at that point there definitely won't be any say so because, oh, well, the line's already there. The line's already there. There's another side of the pole. I mean, why wouldn't we use it? So right now, they make a point of saying, we're going to put up this pole. It's going to be 100 feet tall, 130 feet tall. But we're only going to use one side of it. And it's going to take up, less of the view. It'll be less noticeable and everything. And that was part of what they had told us before. But I mean, seriously, noise and everything else, all this stuff. What's to say that this isn't just going to double over in a year, 5 years, 10 years? Me and my wife, we built our house here planning on this being the only place that we're going to be living. We didn't plan on selling it and moving somewhere else. We also didn't plan on there being a buzzing going on across the street from us. We planned on retiring and going out on vacations and coming back home to our neighbors that we love, in the neighborhood that we love, in the house that we built. And so, I mean, it's a question I would really appreciate, like a real answer to, not just a roundabout. I'm hoping that there's a real answer to it. And maybe it's a stupid question. I'm sorry if it is, but anyways, that's all I got.
Okay, thank you. Is there anyone who still wishes to address the public hearing?
I was hoping to hear it.
Okay. Seeing no one, I'll take a motion from the commission to close the public hearing.
Am I allowed to ask a question to Rocky Mountain based on some comments?
Sure, but do you want to ask the questions in the open hearing, or you'd be able to do that after the hearing?
Well, I'll keep it open.
Keep it open?
Yeah. Am I good to ask this question? Just because something was raised that I have a question with.
Sure.
It's not necessarily. It's just. I feel like a few people talked about, and I think a lot of people came up, but Steve Wilson, I think you talked about feeling like you've been having like communication issues with Rocky Mountain. and again, like we all have different perceptions. But you've also, a lot of comments have come in, or several, that you feel like they feel like Rocky Mountain has also been, like Horton, is it Horton? D.R. Horton has had more kind of negotiating power, or they've been more like able to speak to that. So that they have more of a like a communication corridor with them. So I don't know. I guess I would want Rocky Mountain to speak to that, like, because I think because that would help, because that'll help your case, because perceptions do matter. If the small guy doesn't feel like, in this situation, this is what I'm getting. The small guy doesn't feel like their voice is being heard, but yet Horton, who has a lot of money, their voices, they have like, direct access to Rocky Mountain. That doesn't seem, that doesn't seem like a very, very fair process. So anyways, I'm curious to know what you would speak to that, as a defense to you guys.
Yeah, thank you. That's not the process. I don't know where that's coming from. Every landowner is met with individually. Every landowner gets their opportunity. The reason you may not have had discussion you had discussion at one point, but then it went away for a while, is because, frankly, we're here trying to figure out a process by which we can even have our project reviewed. So there's lots of reasons why that happens. Every property owner, by statute, we're required to meet with every property owner about a project like this if their property is going to be potentially taken or there's going to be an easement across it. You have to. So that happens. It may happen on a different time frame as another property owner. That happens because we deal with different portions of a line at different times. You can imagine how you can't do 500 people all in a week. So you go through and you meet with all of them along a line corridor. And so it's just, I'm just, by statute, we're required to have separate negotiations with every single landowner. So D.R. Horton may own more lots, but they're going to have the same kind of negotiation. We're going to have to say how much is the fair market value of the land through which the line will have to run. And that same conversation will happen too with the farmer who has only one parcel of land. It doesn't matter how many parcels you have or don't. You have the same rights under Utah statute for the same notice, the same meeting, the same negotiation, and the same value. It's all already provided for in law.
What happens with questions that are asked? What do we do with questions that are asked? People have questions out here. Like somebody has a question in the audience. What do we do?
Well, they have 3 minutes to come to the podium. Right?
Okay.
That's the public hearing.
Okay. So you can chat, but and so, and as a business owner, and we had a marketing person that came up here and spoke to that. That it just seems like that is a perception that people are having that are going to be directly impacted. It just seems like it might be beneficial for you guys to address that with them.
I would love to. And what exactly are you suggesting? And what
I don't know. Just have a better communication with the people that aren't feeling like they're being heard.
Well, I do think it's important to address that. Notice was brought up a lot, and I think there's several misunderstandings going on.
Yep.
First of all, this line, because it is federally permitting, it's subject to federal permitting, is not subject to the existing Utah notice requirements that have been referenced in 5418. I said that before, but people keep bringing that up. Despite that, Rocky Mountain Power provided notice, and it provided notice under the law. Now, some people in Salem Park would not have received notice because they're not within the corridor that is required under state law for notice. What we have proposed in the standards makes it broader than what the existing code requires. So when a landowner says, I didn't get a letter, well, that's because you were not inside the corridor required by law for the notice. And I can't say what the U.S. Postal Service does. We provided to the county a list of every property owner. The county has that. Staff has reviewed that. And so we've provided notice to every one of those individuals on that list, which complies with Utah statute. So I can't speak to an individual landowner. All I can say is what we're proposing through this
would provide more notice, not less. It would provide a broader swath of notice than state law requires, and it wouldn't have an exemption where there's federal permitting. Does that make sense? So I agree 100% that there ought to be proper notice. I agree 100% that there ought to be an opportunity for individuals to have discussion. As we talked about earlier, that's fine. We're happy to add in the proposal that there actually would be an opportunity to have a meeting where people could discuss this. But I just want to be clear, there's not a lack of notice under the law happening. And I think I heard somebody say, well, the Utah Public Service Commission, there was some filing. That's inaccurate. What happened was, again, notice was not required, but was done anyway. There was a newspaper posting that was set up, but another project was canceled, and the newspaper canceled all of the notices. So we had to go back and renotice it and held a separate meeting in November of last year to make up for that error by the newspaper. So I just want to be clear, this is not a lack of effort. And we can I think that's a valid place to have discussion about what kind of notice should people get. I think that's great.
Well, and I think it's important. I think like, and that's where I want your, your perspective, and because it does still seem like, even, maybe the best approach is not to do the minimum, right? Well, we check box, do the minimum, but especially in this situation where you are going through some, you're really going to impact property values and what people can do with their property. It might require maybe going above and beyond what was minimally required. I'm just putting that out there.
And I just want to make sure you understand we did.
Okay.
Because we weren't even required to provide notice under the statute that's being referenced, and we still did. So I just want to be clear on that. So
I guess I'm having a little trouble because my recollection of previous meetings, and correct me if I'm wrong, but we were told as commissioners that noticing had to occur. And now you're saying noticing doesn't have to occur?
There was uncertainty about whether federal permitting was required. It is required. And when the federal permitting was required, and I can refer you to the section if you want to in the Utah Code, but where federal permitting comes into play, and we've spoken with staff about this, you were not required to comply with the high voltage state law because the federal law governs. So I wasn't there at the previous meeting, but I think there's clarity about the fact that this is a federal permitting. I'm just suggesting that notice was required by the law, and what we're proposing, this isn't about this specific line. What we're proposing is broader, wider, more notice to more people, for the very reason, Commissioner, that you brought up. So hopefully that helps.
Thank you.
Yeah, so I just want to thank you, Cameron. Cameron's doing a good job advocating for the company. I just want to say that listening to all this, I work on a team for these projects that interact specifically with landowners. I did for Gateway South.
Yeah, please.
I work on a team that's specifically dedicated towards working with landowners on these projects. I did it with our Gateway South project, which you may know came through Utah down here. And I work on a team for this project, and I just want to say that I really appreciate all this feedback because it's highlighted that we need to be doing a better job. Cameron articulated our perspective, and I don't know that we need to get into that, but I want your contact info.
Yeah.
I want to,
I appreciate
our
that.
goal is really to work with landowners.
Yeah, I mean, and that's why I'm bringing it up, because I'm seeing, like, I'm hearing this and I'm never hearing this, and then we've done this, but again, as a business owner, having raised teenagers, like, you want to get the right, like, what's the communication happening here, and if there's a breakdown, which there seems to be to me, in terms, then I think that, as a business owner, I'm going to try and meet somebody more than halfway and try and figure out where we're falling short in communication wise.
That's 100% our goal.
Okay.
We meet weekly and discuss. So, but we need to be doing a better job. So,
yeah.
Two things really quick. In the last big meeting, their team spoke, almost bragged about their communication and working with D.R. Horton and Arrive Homes about development of where the power lines would go. Funny thing is, they're not down the powerhouse corridor that is where D.R. Horton and Arrive are building now. So that's on record.
Thank you.
So,
Mr. Chair, can I insert for a second?
Yes.
A couple things. we need to make sure that people have spoken before don't utilize their additional minutes unless you make a specific motion. We also need to be clear that we're not talking about a process or a procedure of a previous application. We're not talking about a conditional use application and the procedures associated with that. We're talking about a text amendment that's before you tonight. Just want to make that clear. Thank you.
Thank you. So I think one thing I just want to be, if we just devolve into a free for all, then we'll just be here all night. So I want to make sure everyone has had a chance to speak. And I think in this case, there was a specific question from one of the commissioners that was being addressed. So I'm not really, I don't want to open it up for everyone to come back up and give a second, statement. If you have a quick one sentence response to something you heard, then I think I'll allow that, but that's the last of that for now.
I'll be quick. My name is Jason Adamson. I'm a property owner out in Benjamin, and I was curious this whole time why, the whole D.R. Horton thing and why it didn't happen there, and I think I found the answer. And that is that Berkshire Hathaway, which is owned by Warren Buffett, who also owns Rocky Mountain Power, he made two separate investments in D.R. Horton. The bigger bet was in 2023, part of a broader move into home builders alongside Lennar and NVR. They sold out that position by early 2024, and in mid-2025, they bought it back with two smaller stakes worth about 191 to 192 million. So D.R. Horton, owned by Warren Buffett, Rocky Mountain Power, owned by Warren Buffett, food for thought.
Okay. He's already signed because he already spoke to us. Is there someone that has not yet addressed the public hearing
I have
that would
not.
like to?
I would like to defer my time to someone else because my eloquence is not on par. So is that something that can be done?
I don't think that doesn't meet the requirements we had. If you were in a group, he could have taken your time as part of a group, but I think if you want to give some comments of your own.
So mine would just be speaking this to the lack of communication. We live out in Goshen, where my backyard lines right up to the railroad tracks, where is a proposed thing. I know that there's been a different proposal that they'd like to push through, and so I just wonder if that one gets canceled. Do we go back to the drawing board A, B, C? If B gets nailed as no, does it go to C? Like, are we still affected? And would they consider those houses along the railroad tracks to go underground? Is that something that's been discussed, worried about?
Well, like I think just to help you there. So we're not actually discussing. We're just We're discussing the change of an ordinance in the county that would be applicable to all utilities. And so when you refer back to a specific case, it would affect in any utility that would come along in the future.
In a broader sense, and that's just for tonight. And then the next one narrows it down to this project.
Well, if we recommend this and then the county commission adopts it, then that would be the new law in the county.
Okay.
But I don't know. If they would then apply for the regular permit. So there'd be more steps. Yeah.
Okay. Anything else?
Okay, thank you.
So just your invitation of one sentence. I've got one sentence for you. So they've brought up NEPA multiple times. There is absolutely no evidence that NEPA has begun. There's no notice of intent. There's no environmental assessment. There's no draft EIS. There's no scoping notice. There's no BLM project docket. There's no federal registered publication tied to this project at all. There's no e-planning page, nothing like that. So I would say if NEPA has begun, then let's see the proof, because if it hasn't, then this statute does 100% apply. Okay.
My name is Brock Carlisle, and I would just like to agree with everything that's been said tonight. When it comes back to it, keeping the power with you guys is very important. I mean, I don't have a big speech, but if you think about it, we as landowners and property owners, we have to get a permit to put a shed on our land. I don't think that it's right that Rocky Mountain Power can just put a transmission line through our property and not have guidelines that they have to meet, and I mean, frankly, hoops to jump through, because this does affect property, you know, future uses of property and land value. So thank you.
Thank you.
Hi, Landon Ramsey. I'm one of the property owners on Powerhouse Road.
So they're pushing it over to your road, right? That's what I've heard.
Correct. Yeah.
Sorry.
So yeah, we're just north of Powerhouse Road, so it would run through Steve Red and then across Jay Thomas and I. I'm currently building a home. I've done all the work myself. I've worked my entire life for it. Milled my own timbers for my own logs. I'm gonna die there. So for me to stare out my window at a new power line it's heartbreaking. We're sick over it. We understand power needs to get places, right? One of our biggest concerns is that nobody's talked about the amount of trees that they take from that easement. 130-foot swath of trees. Part of our property is river frontage, so they would take 130 feet or whatever it is of trees that would expose our home to everybody on the city trail. So the seclusion that we've worked our entire lives for, our dream home, our dream spot, is now exposed to buzzing. And anyway, that's not the point. I guess my point is, can there be conditions that maybe we could add to amend it and give us a little bit more power to say what's done to our property? Can we have a condition about the vegetation, the amount of vegetation they can take? I know they can't, they have to go a certain height, but they're talking, what's the height of the proposed line? We have 150. Okay, so we don't have any trees. They're 100-year-old scrub oaks that don't get over 20 feet tall. So why do they have to take all of those? Can we do a condition that they have to, protect some of that vegetation, especially along a river frontage? You take all the trees off of a river frontage, and now when a flood comes, and it does down that river, it washes out the rest of our fields. So anyway, I don't understand how it all works. I don't know how this is even a thing, to be honest. It's crazy to me. Please consider that.
Thank you for being here. Is there anyone else who would like to address the public hearing?
Move we close the public hearing.
I'll second it.
It's been moved and seconded to close the public hearing. Is there any discussion about closing the hearing? All in favor say aye. Aye.
I'm supporting you guys.
Any opposed? Okay, it was unanimous to close the public hearing. So, is there further discussion from the commission or questions for the applicant or for staff?
Yeah, I got a lot of thoughts. As it is, I'm just going to say I'm not. I don't think I can support what this is written as it is. What the CUP, the conditional use permit, did last year was allow the process of a stopping point so that the very real situation that residents were not getting notified could be brought to light. Wait, hold on. These residents have obviously not been notified sufficiently. The CUP does have limitations, and I don't want residents to think that the CUP can just hold up a project necessarily. And so, as part of the discussion tonight, I've realized that I think it's important to know that the CUP may not be the best path forward. However, as I said, I don't think that we can pass this. My personal opinion is we can't pass this as currently written. I think there definitely needs to be better protections. I have major concerns about the 135 linear feet being taken out. I have concerns about the location priority, as many people have spoken to, concerning why certain routes are not being utilized. It's hard to say that, using some vague language like "to the extent reasonably feasible, follow this order," and I see residential at the bottom of that list, but I know that this route, that potential future routes could have residential zoning districts, and my concern, I guess, is who is checking to make sure that this has been followed appropriately. So, I'm where I'm at. I've got 3 potential options that I'm considering. We could deny the proposition as it currently stands. I'm not necessarily sure that that is the best path forward, though. A second option is we could put better protections into this and pass that. I'm still also wondering about that May 2025 change that kind of started this process, and maybe the better route forward is to revisit that and fix that. So I don't know. I guess that's my mind at the moment.
Any other discussion, or
I'll make
you okay? Thank you.
Last Saturday, I was at an NFL stadium. My grandson was graduating from high school, and it's massive. And but I was looking at the impacts that stadium had, and the impacts around it were huge. But they were really limited to, I don't know, maybe a quarter of a mile, half a mile, and after that, everything was back to normal. So even that stadium had a limited spot where the impacts were created. One of the unique things about a power line is that it winds its way through the whole county, up mountains, down in deserts, over wetlands, over farmlands, through residential. It's not just a spot that you can look at and say, let's do this. It really is different in every unique place. And so, me personally, I still feel, and I'm going to throw some standards out when a motion is made, just so it's on the record for the county commissioners to have on record. But I think maybe in this situation, I'm personally not a fan of conditional uses, but because of the nature of this use is so unique and so different, that it might be better to keep this as a conditional use for a while, at least until we get some standards that both the power company and the neighbors feel very comfortable with and feel like they're protected, both. And so I'm leaning towards not recommending a conditional use permit. I might just add that I want to thank the power company. I think they did a marvelous job. I thought they were so professional, and I want to thank you for your presentation. I thought it was marvelous. I want to thank the neighbors. I read every letter every one. I've been reading for hours the last couple of weeks from last time. I read the new ones. And I was so impressed with the letters that were written. There are some fantastic ideas and thoughts that I never even had considered. So thank you for the great letters that were written. I really appreciate that. I learned a lot. And then, of course, I'm really grateful for our staff. They're walking a tightrope here, and they do such a great job, and I'm just grateful for all that they do. So that's kind of where I am.
Well, I guess I would echo you in sense of like, yeah, you guys did a good job. I mean, definitely made it very clear. I appreciate you coming in and saying and owning the fact that we need to work on communication, not with just the organizations that have a direct communication route to you, but to the small guys. I think that's really important. And again, as a business owner, I'm going to over deliver as much as I can. And having been an HOA president, like it's like we have to have a consensus, and people have to feel like they're heard. More than anything, people have to feel like they have a voice. And that's really important, and especially for something like this that really impacts people's, I mean, like their lifelong dreams. And if they just sort of feel like discarded and discounted, that's on you guys in terms of coming to some understanding. They have to feel heard, and I really feel that way. And and I love that. I love all the different presentations, and I love this process because you guys have become advocates for your community. I'm sure you guys are even closer together as a community, and especially in this kind of day and age where sound bites seem to impact, make bigger statements at times. I love the process. I love how some people did the research on the animals and soils and all that kind of stuff. And so I just think it makes us a stronger community for that. And I mean, I'm not entirely opposed to this standards-based process, but I don't know. I feel like the conditional use process is still something that has a bigger check and balance. And I agree with Commissioner Sainsbury that maybe for this situation it's a little bit more unique. And I will echo. I think you said this. Just because other people are doing something and other counties are doing something, I don't think we have to be like them. And that's what makes me, when I fly over Utah County, I just think like we have a potential to be a beautiful county in 30 years, or for it to be just like urban sprawl, and people aren't going to feel like they feel comfortable here anymore. And so that would be my comment.
I'm confused, so I'll just I'll hold my comments. So. Yes.
My comments are similar to what's been made. I feel like that when this originally came to us as a conditional use application, we learned a lot from the residents and the citizens that we probably would not have learned had it been a different process. And so I don't know that I'm in favor of taking this type of an item out of a CUP. So
I think my concern is just the maybe impossible requirement that we've put onto utilities. We depend on utilities. I think I mean I'm a little worried that we've just made it so impossible that to get every possible landowner. How many landowners would you mind answering? How many landowners would you need to get consent from for just the county land? Because you're also working with the city. You got to work through all these different jurisdictions, right? So
220.
220 through the Utah County, in the Utah County. So they'd have to get consent from 220 before they could come in and apply for a conditional use. Or change the law.
But that's kind of my point too, is they came in for that without having done that the first time.
Yeah, I agree.
I don't think they knew. I don't think that.
Can I address that? The reason our application for a CUP was put in was the understanding was it was the same process as always. We were, and I can give you a copy of this, your code 16.94 was the one that was amended to add the words at the end of the first sentence on the definition of what an applicant has to complete. The words now say signed by the property owner. We met with your county and your county attorney to talk about that term. It was told to us that it was interpreted to mean every property owner would have to sign before we could do that. Now, that process is why we withdrew the application. That's why we started this separate process, because rather than go to the Facilities Review Board or rather than go to a court or do something else,
we thought it way more productive to be talking with you about what makes sense from a standard standpoint. And we can talk about standards. That's what we've been doing for months. But that's the problem. This process right now came as a surprise to us when that was discussed, and that didn't come up until September of last year. Was when that discussion occurred. So,
so and sorry, if I remember right from the first time this came up, as it was described, if I'm trying to remember the verbiage that was used, but if we don't help, I mean, you can appeal back to the Public Service Board and kind of bypass us anyways.
well, the state system has put in place a process where local ordinances that become overly oppressive or prevent utilities from going through, there's a facilities review board.
Mm-hmm.
There's also a process through the state courts to deal with these kinds of issues. That's always an avenue, but not a particularly desirable one. Not because we couldn't do it. We could. It's much better to have this kind of discourse where we agree upon standards and there's expectations going forward.
And I think that's kind of where I'm at, is that if we make it impossible, an impossibly high hurdle, then you just stop there and bypass us altogether if we keep the ordinance as difficult as it is right now.
And I hope you see that was a decision made by us long ago to communicate, to start this process, not do that, because we want to be good neighbors. That's the point.
So so back to just my thoughts here is I do think that, I don't know, it seems like the avenue is to keep prying at this requirement that we put on there, that I think getting 220 signatures is, I would call that impossible. But that's my opinion. So has everyone had a chance to discuss? Any questions that are still open for staff or for the applicant?
To your point, if we deny this, we need to figure out a different, like you said, there needs to be some process where Rocky Mountain Power can make a proposal and as many of the residents have said, we need to be able to move power around. We need to be able to put lines in. There should be standards and things in place, but so if we're going to deny this, we better have some kind of a plan of, okay, what should be done.
Mm-hmm. Agreed.
Well, I would just add that I think this process brings up some like gremlins, and that could make this a little bit more transparent for people that are impacted by it. So I actually think that it's not necessarily. I think just going through this process, it's clunky. People are staying here all day long. People would rather be home, but in the short term, investing and putting this kind of effort and thought. Now you guys got some feedback from people that are directly impacted, and I just heard you say you want to be good neighbors, right? And I'm gonna think that you really feel that way. Well, some people may feel like that's not the case, right? And so I think it's really important that this process is critical in making it so when something does happen, that people feel like there's a lot of due diligence on both sides.
I mean, I think I agree with you, Commissioner, that there were a lot of solutions even offered through the comment. Setbacks taken out. Maybe that could be put back in a revision that would be, more agreeable. I do think noticing people about something and having a public hearing are two different things, and so I do feel for the loss of the chance to hear about it in a public setting and public hearing setting. That would be lost without the conditional use application process. But we've got to make a conditional use application process that doesn't have an impossible hurdle before they can even apply. And I think that's where we are right now. So we're just going to push them into the court system, or we're going to push them into, I don't know, going back to the, the Public Service Commission or whatever, and work it out through them and bypass us if we make it too hard.
So the question I have, clarification, but I thought it was my understanding that Rocky Mountain Power has to make an agreement with every property owner that their property is impacted, correct?
So we're kind of talking about two different things. This conditional use process is just getting owner consent to file a conditional use application. That doesn't circumvent the normal process of obtaining a right of way. That's independent. And so the challenge, the procedural challenge right now exists with the conditional use consent of 220 in this case, application, or a property owner signing the application. A couple other quick things, just for clarification: the conditional use is not a public hearing. It's been mentioned several times that is not a conditional hearing, or that's not a public hearing. And so that needs to be clear that does not exist at the conditional use stage. The other thing I'd say is your action tonight is a recommendation. It will go to the county commission. You can recommend denial, and they can consider that. They could you can recommend approval or approval with conditions, whatever. They'll consider that. They have the ability to go forward with your recommendation. They could go forward with a different recommendation. They could kick it back to you. But just want to be clear, like that's kind of the process that we'll see this through.
So, and I guess I understand it is onerous to get a signature from every property owner, but they have to do that at some point anyway. And we've already spent almost a full year discussing this when multiple property owners haven't been contacted based on their feedback.
Yeah, I mean, right, that's
get that process going, get those contacts made, and
well, that's a third process. I mean, they
will go along.
Obviously they want to have a defined corridor so they know what they're dealing with as far as acquisition, and then at that point, yeah, they have to, even if it's a conditional use, they still have to bring that owner consent at the time they get their land use permit. So that's the same process in either avenue.
Can I address that comment? I think I want to make sure we're talking the same thing. So when we're planning a line, at that point in time, we're trying to figure out the location. That gives us information about who would be impacted. So historically, under the CUP process, we would come to the staff with a proposal. That would then be adjusted based upon whatever was required. There would still be landowners affected by that line. It could be the same ones, it could be different ones, but you're going to have to go to those landowners. Under the CUP process, there was no initial contact with people at that stage. What you're talking about when you're talking about having some sort of agreement with the landowner is down the line, way down the line. It has nothing to do with the permit process. It has to do with once you've identified who the landowners are that are impacted, you then, under statute, are required to go to that landowner and try to negotiate the purchase of usually an easement across the property. The statute requires that it be done in a specific way, one-on-one with that landowner. If the landowner then consents to that price, that's done, and you're over, and the land has been acquired, and we're out. That is often that's the most common thing that happens. When we did Gateway South, I think it was like 95 or 96% of all landowners worked it out like that with us in talking it through. But that has nothing to do with the permitting process or identifying where it's going to go. That's what the CUP process was previously used for, and that's why we're suggesting a process that is workable is what we're looking for.
So to that point, weren't there 2 or 3 different alignments out there, and then someone made a decision on this specific alignment?
So there's more than 2, I bet. I don't know how many. Usually you start with, sometimes we get up to a dozen or more initial options. And as you look at federal requirements and state requirements and endangered species and water requirements and land geotechnical stuff
We do take into account geotechnical stuff. All of that has to be taken into account, and that narrows your list of routes down to sometimes one only, sometimes it's one or two, and then you try and figure out between those what is the preferable route based upon all those factors. So yes, there was a process. I'm sure for this line, that process started years ago and narrowed down to what was proposed. Hopefully that helps answer.
Yeah, I understand some of the points you made there, but I would certainly hope that during that process, taking into account all of those features that you've described, that there would be a lot of interaction with the property owners, because again, that would determine the cost of your line. And if you've got people that potentially have millions of dollars worth of property that's going to be developed, and you're going to have to pay for the impact of that, that's going to affect your decision of where that line goes. So all those other requirements, federal, soils and all this kind of stuff, I would certainly think that discussions with property owners would be up there right along that same group, because again, the cost of acquiring that property or mitigating the impact of that property could certainly affect the alignment.
So understood. Let me make sure I present kind of what the problem is. You theoretically could have 12 different routes. If you go out and contact every single property owner, you might be contacting a bunch of property owners that would never be impacted because you would never put the line in that spot. So you end up generating thousands of people who think they're going to be impacted and they're not. So what the process really does is it narrows it down to the ones that are, with all factors considered, including price, including cost, because we have to do that. When we take a line and go seek recovery from the Public Service Commission, we have to explain why this route was the preferred route. Why did it make the most sense? Why was it the most cost effective? Why was it the one that complied with all the ordinances? We already have to do that, and so that happens. And so when we select a route, we've already gone through the process of saying, what's the most expensive? What's the least expensive? What's the best for public thoroughfares already, where we're using a railroad track or where we're using a road? I think we could have one of the engineers come up and they could tell you they've spent hundreds or if not thousands of hours trying to plot what makes the most sense and with all those factors. So that work is done. Once we get to a place where we kind of know, then you do get some customer interaction. You do get, but there's no reason to set off alarm bells with everybody where you may not even do a line. Does that make sense?
Yes.
Yeah.
Can you, just while you're here, and maybe it's staff actually, but like there was some setbacks or some like some distance requirements that were removed, and it seems like that's probably generated a little bit of angst here. So, like, can you explain how that
I'll make
came
a comment,
about?
and staff may want to comment because they actually came to us with that proposal.
So I kind of want to walk through how did that come about?
As I understand it, after we initially started down this road, and there was an idea of standards that needed to be developed, staff said, well, we've done some research, and it looks like in order to meet the noise ordinance, it would have to be approximately 135 feet. And I don't want to misrepresent that. That's what I understood. To that, we said, that's not exactly true. And you don't want to set, if you set a setback, and I heard people say 500 feet or 300 feet, remember that if you set a 500-foot wide easement, we just take more land. You don't want that. You want something that's workable that doesn't prevent you. Remember, you can't build under a line. So if we widen a corridor to 500 feet, all you've done is make it more invasive, not less. It means that you take a house instead of just an easement. If you have to build a line in a location, and then there's a home sitting within a 500-foot corridor, we don't get an easement through a home. You take the home. We don't like to do that because A, it's more costly, and B, it takes somebody's home. So you want to set a distance that protects that makes you in compliance with federal, state, and local law, including the noise ordinance, including all this other stuff. But you don't want to make it fixed. The reason you wouldn't want to set a fixed number is what if a landowner wants it
less than that? What if it's better in that location and would actually cause less harm to have it be a different kind of area? So that's my comment, that when we met with staff, we walked through all of that. And I think as we talked through, we understood that on this line in particular, if you widened it to 135 feet, you're going to lose some homes instead of just an easement. And that's not a desirable outcome. So I hope that helps. And I don't know if staff wants to say anything about that.
Comments from staff on that? I'm not sure I understand. I don't know why you can't have a setback from a home and not widen your easement. In other words, let's say you got a 50-foot easement and there's a home 300 feet away. That doesn't mean your easement has to be 300 feet wide. Those are two separate issues, as I see it.
Well, let me make sure I'm clear. So let's say you run a line. If you ran a line through Utah County and did a 500-foot wide corridor, you're going to go through some homes.
Sure.
So what do you do in those circumstances? If you set an arbitrary distance, you will require the power company, instead of just taking an easement across their property, that house has to go. Because you're saying under your law, we can't have the line within 500 feet of a home. Well, if you're shooting a line through Utah County, you're not going to find a place where there isn't a home in that whole corridor that is in. Sure. Does that make sense?
Yeah, but all you've got to say is no power lines within 300 feet of a home, and if you do want to have a power line within 300 feet, you bury it. So it's okay not to buy the home out. You just bury it. That's you know what I'm saying. And I know it's more expensive.
Well, it's a cost to the county. I need to make sure you understand. If you do that, the Facilities Review Board will require the county to pay for that. So that comes out of your budget, not ours. We don't like that because it's an unnecessary expense. But the Facilities Review Board would say to that, and we've been through this with Park City and with Heber and others, you put into place an ordinance that requires something like that. The Facilities Review Board's job is to say, is there a legitimate reason that it has to be undergrounded, or are we doing it because of a landowner convenience or desire? The state law will say to that, if you underground, the county has to pay for it because their ordinance is requiring that. That's what that. So we're not trying to make you have to pay for that.
I guess I'm looking at it in terms of this county is growing so quickly that it's going to be wall-to-wall city. All the county space, unfortunately, for the farmlands, most of them are going to disappear, and there's going to be homes and businesses here. That's just the nature of it. Hopefully, we can preserve some, but that's going to happen. So I kind of think we have to look at Utah County a little differently than just this large rural farmland, and now we got to start realizing that all these big power lines that we're putting up are going to be going right through cities and homes in the future. So maybe we get some help from the state legislature, because I feel for power companies. I mean, if it were up to me, I would have the state legislature set all the standards and all the reviews so that you had all the same in every county and every city, and the whole state knew exactly what you had to do. But I feel bad that you have to go through every different city and every different county and figure out different rules and regulations. I think that's a nightmare, but I think the state's chickened out and doing that and said, well, let's just dump that political animal to the local government to let them take the heat. That's just, I don't know if that's true or not, but that's my feeling on it. So maybe the state can step up and say, this is a new era. We keep talking about we want to do this high tech stuff, but do we really want to put huge power lines everywhere through our county? And so I don't know. I just, if you look at the future and look at what this county is going to become, I think we want to make it a really nice place for business, for homes. And I just wonder if we might need to change the view a little bit from where we are and say, the way we're going, maybe we ought to rethink this on a state level as well as on a local level. That's probably, anyway.
I appreciate that. And actually, the growth you're talking about, I mean, there's a reason this line is being built. It's not because people want to just do a line. It's because there's demand. And you have to get power to the places where people are building and where there's businesses and where there's, that's the challenge, right?
Thank you. Is there additional questions for staff or for discussion of the applicant? Anything? If not, is there a motion?
I think we got to do one of two things. We either need to deny it and revisit that that May 2025 change, figure out a better situation there, or we should pass some better protections than what's listed here. But I'm not, I guess I don't know. I have a hard time knowing what better protections would work. I feel like that's almost that would need to be a process that I think, I don't know. But if we deny it, how do we ensure that we revisit that other rule?
Well, the potential is we deny it, it goes to the county commissioners and they approve it.
Right.
So.
Well, that's always a possibility, right? This is only a recommendation to the county commission.
Recommend the county commission deny it and revisit the rule change.
Rocky Mountain can file an application to revisit that, and I think, can staff file an application to revisit that? Or is that not what something?
Yeah, we can. We can also maybe schedule a work session to explain the reasoning behind it and kind of the circumstances behind it. But yeah, those are options.
I mean, so we can deny and then we can request staff to come up with, to look at that specific language and see if there's any suggestions they would make, and then we could discuss that.
I think having a work session would be good.
Work session. Okay, so is there a motion then?
I'm not articulate enough to do it, but I'll try. I make the motion that the Utah County Planning Commission recommend denial to the Utah County Commission of the proposed Utah County Land Use Ordinance text amendments to Section 844, based on the following findings: that staff review this and come back with a recommendation that covers the concerns that many of these people have tonight. That's pretty general, but that's the beginning. I'm welcome to any other additions or suggestions.
Well, and I would add and whatever Rocky Mountain has learned from this process, to take that into consideration as well. So not taking into consideration what the public has said, but also Rocky Mountain, some of these concerns. And the big thing I'm seeing is like a total, like just the communication. And even though you said and they said, I'm still seeing from this perspective that there's when people's livelihoods are at stake, that the communication has to be a lot better.
Mr. Chair, I think I just would add, I think it's a little problematic with that motion with a recommendation that's going to the commission.
Yeah.
I think we want to see that through to see they may send it back for direction, but I think to have a recommendation with an action and then until that's completed to kind of wait for further action on another land use regulation. We can certainly come back and give you some information about the procedural challenge with conditional uses, but I think this subject application would need to go onto the county commission for a final action to see what that results in.
So we need a motion that is specific just to this.
Well, we need something that can be, sent to the county commission and read to them as here's the reason for denial and a recommendation, right? So that's who we're actually addressing this, either passing or denial to, is to the county commission. So it'll be read there. We can't tell the county commission to give us some ideas, right?
Just postpone. I'll withdraw that motion, make another suggestion that we table this and recommend it go back to staff and review the Rocky Mountain Power and then the folks here their thoughts and recommendations and come back with another recommendation.
My concern with that is, I think the city, the county commissioners need to be aware of the issues, and the findings are in the minutes. When all these minutes we publish, when they get our vote, and they'll say, well, why did they do that? They can look and read the minutes and find out what they said and what we said and why we made that proposal. So my proposal would be just make a motion to recommend denial of the conditional use permit change.
Just deny it with no reason. Just look at the record.
Minutes, they know what we said and what we're thinking.
I would say these are just my ideas. I know we're trying to work on a motion here, but I think it seems like denial. I would recommend denial with the findings are that setbacks are not explicitly stated in the permitted use. The setbacks were replaced with a notification for right-of-way, which does not really give the public a chance to address. They can make comments to the utility, but they're not able to. They're not necessarily making comments back to a governing body. So I think I would say the main finding is that we want to retain the ability to review and grant conditional use permits based on mitigating detrimental, factors that have been discovered and that they can show that they've mitigated them, which is what a conditional use would do, right? I mean, if they can mitigate them all, then we have to approve, right? That's the main problem with a conditional use for the people in the audience, is that if they can show that they've mitigated them all, then we have to approve. But I think we're saying we're going to deny it because we're giving up the chance to review and to address conditions that we feel are required to mitigate adverse effects.
Kind of hard to make a motion. Like, how do you get things?
As I read through some of these things here, and I'm just going to throw this out there, see if it helps make a motion. One of the concerns is compatibility with protection of surrounding land uses. Is that what we've heard? So that could be part of the motion, perhaps, to work on language that, protects that. There's promotion of efficient, predictable permitting consistent with public interest. That's the goal, I think, that staff and Rocky Mountain Power would like to do as well, is to create a process where permitting process is a little bit more efficient. So I don't know, just throwing some stuff out there that it's, in black and white here, that if that gives us a direction to go. Or we could rely on legal counsel to give us a good motion. Just accept the way it is, right?
You got three.
What's
by
that?
ordinance. You recommend for, against, or you recommend an alternate amendment. You've only got those three.
Yeah, those are the only three. Agree. Well, but it does say findings to be determined, so it does kind of.
If we don't need to do that,
that's not in the ordinance.
That's not in the ordinance. So good.
If we don't need to do that, then just recommend denial.
That was confusing. That's why we're all sort of being.
We were just.
I'm just saying.
We're not sure.
All right. Recommend denial.
Yeah.
It may be because the county commission wants to know why, but the best comment was they have this entire meeting.
Sure.
I can refer back to. That makes it a simple motion.
Okay, let's hear the simple motion.
You can make me say it. That the Utah County Planning Commission recommend denial to the Utah County Commission of the proposed text amendment to Utah County Land Use Ordinance 8.44.
Second.
been moved and seconded. Any discussion remaining? Okay, if there's no discussion, all in favor say aye. Aye. Any opposed to denying? Say nay. Okay, it's unanimously passed on as a denial at this point. I do think for Rocky Mountain, I think there's room to address some of the issues that were brought up and try again.
Come back.
Yeah.
So just as a point of clarification, this will be forwarded to the county commission. We'll wait until we receive the minutes.
Sure.
And then, so if anyone who's interested,
Before we lose everybody, my client just asked me to make an announcement. For anybody who has project-specific questions, the company will be reaching out to those who would be affected by this. Again, after, as this process is going, there's been a delay because of this. And also there is a website with email addresses from which people can send an email and ask for somebody to return any questions they have. So we just wanted to make sure that was clear tonight.
Thank you.
I would encourage residents talk. There's a chance for communication here between Rocky Mountain Power and residents. I think.
Yeah. Right now.
Oh.
People who are affected are not just people who it's the actual land they're putting the lines on.
Yeah.
It is literally 200 feet away from my backyard. It's not on my.
Okay, thank you. The public hearing has been closed. So, Bryce, did you have?
Glad we all agree.
I just was trying to say the
Glad-
next
glad
step.
my
It'll be
talking
going
point.
Can you please take your conversations out so we can finish our meeting? Thank you, people.
We'll forward this to the county commission. That date will be found on the county commission's website. They meet generally twice a month on Wednesdays at 2:00 if anyone is interested.
Okay, thank you. Okay, just going back to our agenda to make sure we finish up with this agenda. Do we have any other business?
Public comment.
No, we do not.
No other business. Good. We do have on our agenda public comment.
I think we've had plenty.
And so we actually, I think we're required to open it to public comment based on our.
You can give people an opportunity if they'd like.
Okay, so I'll entertain a motion to open it to public comment. Let's see if there's any.
So moved. I don't think you have to vote on it.
Okay, all in favor of opening public comment?
I don't think you have to vote on that. You just open it up for public comment.
All right.
Okay.
We're open for public comment. Same rules apply. 3 minutes. If you want to.
Okay, that's great.
Name.
Oh, I'm Joseph Ibarra. Sorry.
We don't know your name enough.
I know. I'm sorry. Yeah, a couple of things real quickly. I actually would love, Dale, if you could look up the actual law that says that it has to have the signature, because I'm pretty sure that doesn't exist.
Comment typically to address non-agenda items.
It is.
I can address whatever I want in public comment, right?
Yeah, they can. We
okay.
Don't respond.
So yeah, Dale doesn't have to answer. I mean, that's fine. But no, I'm pretty sure that doesn't exist. Well, sorry, it's not that it doesn't exist exactly. It's a recommendation by another government agency. It's not a law. They say typically you have to have the signature, not for sure. Okay.
Well, I think that would be awesome if we could determine that, because
Awesome.
like I said, I think my worry, as you heard, is that we're going to make it so hard. They're just going to say, well, just forget it. We're never going to go to, avoid Utah County. We'll just go straight to public commission. We'll bypass all this.
Totally. Yeah, no, 100%. So I just want to make sure that you are all aware of that fact, that you can push harder on that in the future.
Yeah, I just want to make sure it's not avoid Utah County for their projects. It's avoid going down to Utah County Planning Commission because we've made it so hard for them to work with us. That's all. Yeah.
Awesome. So that's one thing. Another one is they talk about NEPA constantly. They're like NEPA this, NEPA that, because if they have NEPA, they don't have to watch this law. It is not started. They have to provide any evidence that it started, and it hasn't. There's like 5 different places online you can find out if NEPA started, and none of them show it.
Do you think it's that they haven't got a permit, so they haven't, is it, does that
Chicken
come
and egg
after
kind of
they get the permission, conditional permit, then they,
NEPA is expensive. It really
Yeah,
is.
Yeah, well, so NEPA can take a very long time.
Yeah.
I think strategically what they want to do is actually obtain the permits first, because then NEPA will go faster once they actually invoke it. Once they give all the power over to the federal government, they know it's going to take forever. It takes like 9 to 10 years. So they're trying to play both sides. They're trying to say, hey, it's federal permitting. We don't have to follow the law, but it's not because they haven't started it. So anyways, there are a couple of things for you guys to know. Also, let me grab a couple of other ones real quick here. Putting line it against him.
3 minutes for not yet.
So just can I just say something? I'm a little uncomfortable talking about this when the applicant is not here. It's a fairness issue of, you know what, I want everyone present when everyone's talking about it, because I'm a little uncomfortable. You can say what you want in a public hearing, but I'm feeling a little uncomfortable talking about it when they're not even here to defend it. So
they couldn't hear.
they left.
Yeah.
The agenda wasn't finished. It wasn't adjourned. But the vote had taken place.
Yes.
Right. But he's just educating us, and I can go home and do
Okay.
the work and see what
Commissioners, just don't respond. Public comments.
I mean, there is public comment. It's on the agenda.
Let's let the public comment and let's keep our own
Yeah, but it is all on record, so it's fine, right? Like, I mean, ultimately, like legally and ethically, this is totally fine. They can go and watch this, right? The one last thing is that they kept on saying that they're required to do impact studies and everything, and it's like, show me one impact study that they performed on this line. They don't have them. I'm telling you that. They do not have them. We've pushed them very hard. It hasn't been done. So they said over and over that they did that, or that they're required to do it, and they never did it. So anyways, there you go, guys.
Thank you.
Thanks for hanging out.
Are you allowed to get an impact report? Like, I mean, like environmental impact statement. I mean, I don't know how that works.
No, so their very first application, they reference the fact. They say oh, we're going to follow the path that least impacts the nature and all the stuff, right? They just reference that fact. They never did an actual impact study. If you ask them directly, say, just show me a impact study. They cannot do it. Also, I mean, so the references, maybe you guys have read this, I've sent you a whole bunch of stuff, but the references around undergrounding as being 15 to 20 times more, then their representatives also said after the fact, no, our head of ops said, no, we're just not doing that. We're just not looking at it. And they never did any sort of study with that at all, zero. It was purely a top-down decision that was just like, no, we're not even looking at it. And we have that on record. And it's been sent to you guys a couple times. But anyway, I appreciate you guys.
Thank you.
Yeah.
Is there anyone else who would like to make public comment?
Keep us here later.
Okay, if there's no one else, and we are at the end of our agenda, the meeting is adjourned.